the Pledge of Allegiance.
Thank you.
Pursuant to NJSA 10:4-1 et sec, the Open Public Meetings Act, notice of this
Not
meeting,
special, sorry.
just regular ordinary meeting of the Jackson Township Zoning Board of Adjustment has been published and posted in all appropriate locations.
Thank you. Before we move forward with roll call, I'm going to need a motion and a second because we have an acting recording secretary this evening due to illnesses. So I'll need a motion and a second, please, to appoint Fran DeBell as our acting recording secretary for tonight.
A second?
We have a motion. We need a second, please.
Second.
Roll call, please.
Mr. Bresci?
Yes.
Mr. Hyman?
Yes.
Dr. Hofstein?
Yes.
Mr. Hudak? Ms. Parnes? Yes. Ms. Rosal?
Yes.
Mr. Martins is absent. Mr. Such?
Yes.
And Ms. Bradley?
Yes. So we have our acting recording secretary for this evening, and that covered roll call as well. And Ms. Cipriani, we have resolutions this evening?
Yes, we do. We have several that were before. We've got the Resolution 2025-4, which was granting amended preliminary and final site plan approval with variance relief on properties located at Harmony Road, Block 4801, lots 5, 6, 8, 9, and 10. This was an application that was heard back on November 4th and approved at that time, which was reducing the number of market rate units from 202 to 195, with affordable housing units to remain at 40, but no longer to be integrated into the building, but to remain on the property in a separate building. And the eligible voters are Mr. Hyman, Dr. Hofstein, Mr. Hudak, Ms. Parnes, Ms. Roselle, and Ms. Bradley.
I'm sorry, can you give me the names again, counsel?
Sure. Mr. Hyman, Dr. Hofstein, Mr. Hudak, Ms. Parnes, Ms. Roselle, and Ms. Bradley.
Thank you. We need a motion?
Motion and a second, please.
Motion. Second.
Roll call.
Mr. Hyman?
Yes.
Dr. Hofstein?
Yes.
Mr. Hudak? Ms. Parnes?
Yes.
Ms. Rosal?
Yes.
And Ms. Bradley?
Yes.
Next, there's a series of resolutions. We're essentially memorializing actions taken by the board regarding the appointment of professionals. First one is 2025-05, appointing Morgan Engineering LLC as board engineer for the period of January 1st, 2025 through December 31st, 2025. Eligible voters are Mr. Bresci, Mr. Hyman, Dr. Hofstein, Ms. Parnes, Ms. Roselle, and Ms. Bradley.
Motion to approve.
Second.
Roll call, please. Roll call, please.
Mr. Bresci?
Yes.
Mr. Hyman?
Yes.
Dr. Hofstein?
Yes.
Ms. Parnes? Yes. Ms. Rosal?
Yes.
Ms. Bradley?
Yes.
Resolution 2025-06, appointing Remington and Vernick Engineers and Affiliates as board conflict engineer for the period of January 1st, 2025 through December 31st, 2025. Same eligible voters. Oh. Yeah, on the first one, yes, I'm sorry, and Mr. Hudak is correct. I also, well, my goal is to get through these appointments, which have already occupied far too much of the board's time, in ways that we could maybe streamline the process next year, can wait for next year. So the eligible voters are Mr. Presti, Mr. Hyman, Dr. Hofstein, Mr. Hudak, Ms. Parnez, Ms. Rosal, and Ms. Bradley.
So we have a motion by Ms. Parnez, is that correct?
Yes.
And then
Second.
Roll call, please, Fran.
Mr. Bressi,
Yes.
Mr. Hyman,
Yes.
Dr. Hofstein.
Yes.
Mr. Hudak.
Yes.
Ms. Parnez. Yes. Ms. Rosal. Yes. Ms. Bradley.
Yes.
Resolution 2025-07, appointing Remington and Veronic Engineers and Affiliates as board planner for the period of January 1, 2025 through December 31, 2025. This time, truly, the same voters are eligible.
We need a motion?
Motion and a second, please.
Motion.
Roll call, please.
Mr. Bressi.
Yes.
Mr. Hyman.
Yes.
Dr. Hofstein.
Yes.
Mr. Hudak. Ms. Parnez. Yes. Ms. Rosal. Yes. And Ms. Bradley.
Yes.
Resolution 2025-08, appointing Remington and Veronic Engineers and Affiliates as board traffic engineer for the period January 1st, 2025 through December 31st, 2025. Same voters are eligible.
Motion and a second, please.
Motion to approve. Second.
Have Mr. Hudak as second. Mr. Bressi.
Yes.
Mr. Hyman.
Yes.
Dr. Hofstein.
Yes.
Mr. Hudak. Ms. Parnez. Yes. Ms. Rosal. Yes. Ms. Bradley.
Yes.
And 2025-09, appointing CME Associates as board conflict traffic engineer for the period January 1st, 2025 through December 31st, 2025. Same voters are eligible.
Need a motion and a second, please. Oh, there you go.
Second.
Roll call, please.
Mr. Bressi.
Yes.
Mr. Hyman.
Yes.
Dr. Hofstein.
Yes.
Mr. Hudak. Ms. Parnez. Yes. Ms. Rosal. Yes. And Ms. Bradley.
Yes.
Resolution 2025-10, this is simply memorializing the appointment of Gertner Murphy LLC as board attorney for the period of January 1st, 2025 through December 31st, 2025, on January 8th, 2025, and ratification of acceptance of the resignation of Gertner Murphy LLC from the position of board attorney effective January 10th, 2025. All voters are eligible, as this is a new resolution.
Motion and a second, please.
Motion.
Roll call, please.
Mr. Bressi.
Yes.
Mr. Hyman.
Yes.
Dr. Hofstein.
Yes.
Mr. Hudak. Ms. Parnez. Yes. Ms. Rosal. Yes. Mr. Martins is absent. Mr. Such.
Yes.
And Ms. Bradley.
Yes.
And finally, Resolution 2025-11, memorializing the appointment of Rothstein, Mandel, Strom, Hallman, Cipriani, PA, as board attorney for the period of January 15th, 2025 through December 31st, 2025.
Need a motion and a second, please.
Motion.
Second. Mr. Bressi.
Yes.
Mr. Hyman.
Yes.
Dr. Hofstein.
Yes.
Mr. Hudak. Ms. Parnez. Yes. Ms. Rosal. Yes. Mr. Martins is absent. And Mr. Such.
Yes.
And Ms. Bradley.
Yes.
And that is all the resolutions that we're on for this evening.
I'm going to ask anyway, I don't think we do, but if we have any minutes for this evening?
I don't think we do have any minutes.
Okay.
No.
All right. And do we have a voucher for this evening?
Yes, we do. We have a voucher from King Reporting.
Okay, I have a voucher for King Reporting for the acting recording secretary for this evening in the amount of $175. I need a motion and a second so we can get this paid.
Second.
Roll call, please.
Mr. Bressi.
Yes.
Mr. Hyman.
Yes.
Dr. Hofstein.
Yes.
Mr. Hudak. Ms. Parnez. Yes. Ms. Rosal. Yes. Mr. Such.
Yes.
Ms. Bradley.
Yes. Ms. Cipriani, do we have any announcements this evening?
Yes, there are two. The board secretary has advised me that The application listed as number 1 on the agenda, Ursinoe Guevara Villalobos, which had been carried from the December 18th meeting, has been carried to the March 19th, 2025 meeting, no additional notice being required. Also, number 3 on the agenda, and it's a little bit confusing, but it's only number 3, not number 2, Cardinale and Jackson Crossing, number 2, Adventure Crossing, amended preliminary final site plan, Phase 1, is being carried to the March 5th, 2025 meeting with no additional notice.
All right, we need to swear in our professionals.
Please raise your right hand. Do you swear the testimony, information, questions, or comments you are about to present for the board represent the truth, the whole truth, and nothing but the truth?
I do.
Yes.
I do.
Please say your name and position for the record.
Ernie Peters, Board Planner.
Mark Romeyer, Board Engineer.
Jeffrey Paporo, zoning officer.
We are not having executive session for this evening, but we do have a matter for discussion. With all the changes over the last couple of weeks, we still need to appoint an alternate secretary. So if someone would like to discuss or make a motion. Anybody make a nomination or? Okay. We have a nomination for Christabel, and he's,
Second,
I'm sorry?
asking for a second?
Yes, please.
Second.
All right. We have a nomination, a motion and a second. If you take roll call, please.
Mr. Bressy,
Yes.
Mr. Hyman,
Yes.
Dr. Hofstein.
Yes.
Mr. Hudak. Ms. Parnes. Mr. Such.
Yes.
And Ms. Bradley.
Yes. And now we move on to our other matter for discussion, County Offices LLC, Megan's Associates Site Plan 644-1-B, administrative approval for landscape plantings. Mr. Pfeffer?
Good evening, Adam Pfeffer, attorney on behalf of the applicant. A request was made and submitted by Mr. Borden, someone that will have him sworn in a minute, seeking a landscape amendment to the previously approved application. I think it's fairly straightforward. If we can have Mr. Borden sworn in, well, then he'll walk you through the change that we're seeking.
Oh, sorry. Nope. Thank you. Do you swear the testimony, information, questions you're about to present for the board represent the truth, the whole truth, and nothing but the truth?
I do.
And please state your name and your position and
Certainly.
for the record.
Ian Borden, President of Professional Design Services, Lakewood, New Jersey, a professional planner licensed in the state of New Jersey. Graduate of Rutgers University too many years ago to count, and testified in front of this board for quite a few years. Thank you.
I would just like to point out on the agenda, it states he's engineer, but he's not the engineer. I'm sorry? Can you hear me? Well, if I turned it on the right way, it would help. Thank you. So, Mr. Borden, we accept your credentials. Just for the board members, it says that he's the engineer, but he's not the engineer, he's the planner. So just for the record. Thank
Yes.
you.
Mr. Borden, for the record, you're giving testimony this evening only as a planner, is that correct?
That's correct. Good evening. As evidence of when I made a joke about my college experience, I started this project almost 20 years ago. I, with Adam's former partner, I guess, right? Ray Shea, presented a site plan application. Anthony, could you pull up the exhibits, please? We have A1 through A3. The property is located on North County Line Road, just west of Brewers Bridge Road. It is a site that was zoned multifamily and highway commercial. Nope, that's the wrong project, Anthony. That would be the county office's file. The property was zoned multifamily and highway commercial. The proposal was proffered to construct a office building, 3-story office building, That project was granted preliminary and final site plan approval along with the D variance because the office was not permitted in the multifamily zone. The lot was split zoned. That approval was granted in July of 2008. There were 3 public hearings on that project over the winter and spring of 2008. Thank you, Anthony. The property is in yellow, and what we're going to be talking about is on the right side of the page. You see County Line Road along the bottom. This is the property. The project is completely constructed. That's the office building with the white-looking roof. My thing just stopped working. And you see 3 Pence Brook to the south and to the west, or east and south, to the right and top of the exhibit. Again, we had 3 hearings on this project. Several members of 3 Pence Brook appeared, objected. We had TRC meetings. I know we had 1 at the very least, possibly more that I recall. And as a result, among the many things discussed, obviously, was the buffering and landscaping between the office and the condominiums. Please go to A2, Anthony. And what you see here is the approved plan. The orientation is different. You see the office building in the light brown, the 3 Pence Brook buildings in the darker brown, and the light green is the existing woods that remained. And then the dark green of circles, it was agreed during the hearing process that we would plant a single row of evergreen trees along the 3 Pence side of the forest, basically in their backyard. And that's the way the project was approved. And the project awaited a buyer, and fairly recently, a couple of years ago, the project started construction. Excuse me. And in October of 2024, I was contacted by the developer who I had been helping the entire time doing site engineering and survey work, et cetera. And they had a legitimate question, which is, how do we plant these trees on somebody else's property? We ordered these trees, we want to plant these trees, how do we plant them there? So I contacted the township offices. They assisted me, Mr. Purpro assisted me in contacting the homeowners association. I set up a meeting with the homeowners association that was held on November 5 of 2024. We walked the site, discussed it. We learned at the time that they have a sprinkler system in their lawn area, so that certainly created some challenges to planting the trees. I identified a number of challenges besides the fact that permission was needed simply to plant these trees. That the trees being planted were very close to some of the buildings. You can see, especially on the right and left of those 3 buildings, it gets very close to those buildings. The existing trees were growing out over the lawn. Because that's a southern exposure, they kind of grew out towards the condos, so they had to be trimmed, which would probably, in my opinion, kill the trees. It would disrupt their existing irrigation system. It would damage the lawn area, even though it would be replaced. It would be temporary disturbance, and it would create perpetual maintenance obligation for the HOA. So I suggested that why don't we just plant the trees on the office side of the project, as a normal project would do, put the screening trees on the property that was constructed last. It was agreed verbally, but understood that that was not an approval by the entire board. My client had purchased the trees because he was very close to obtaining a CO. And when you purchase trees from a landscape nursery, once they're dug out of the ground, they're out of the ground, they got to be planted, right? You can't, it's not a returnable item. So they planted the trees along. So I was directed by the board professionals to apply for what we are here for tonight, this administrative approval, which I did 2 days later. In the meantime, my client planted the trees, and please go to the third and last one, Anthony. And here you see the trees planted. A little hard to see, but the trees planted. Unfortunately, my pointer died. The trees, thank you, Anthony, planted on our side of the property line. So that's what we're seeking. We're seeking administrative approval to change the location of those trees from the HOA property to the subject property. In my opinion, that's more appropriate to land planning as we know it, landscaping as we know it. It serves the same benefit to the homeowner association, and doesn't burden them with any disruption to their property, their sprinklers, their grass, and maintenance. And that basically concludes my, my presentation. So that's just simply trying to move the trees.
Any questions or comments for Mr. Borden?
Through the chair.
Mr. Hyman?
Mr. Borden, is there a specific reason why they proposed originally to put it in 3 pens? I mean, the normal process is you put it on your own property. There must have been an exceptional reason why they.
I wish I could answer that. I tried really, I don't remember the answer. I was at all the hearings. I did the testimony for the project. I remember the TRC meeting. It was at Mr. Shea's office where we met with the board professionals, and that was one of the topics. I even went through my entire file this afternoon, all the 2008 documents, the review letters from the engineer at the time and the planner, Worker Vat Associates. I cannot find anything. Unfortunately, Ray is no longer here to ask. I wish he were, for many reasons. But I'm sorry, but I do not recall. I will tell you this, though. One of the things I noticed, I skipped over this, when I went out in the field, and I hadn't been at the site in a number of years. I wasn't at the site since the construction started, but I certainly knew the site before the construction started. And what I noticed was the forest that remains between the HOA and the property was much different. It was evident to me, and I am a licensed forester as well, so I know what I speak of here, that it was evident to me that, and I believe it was Superstorm Sandy caused damage to the trees. There were a number of trees in that strip of forest that had fallen, were broken. So it wasn't the same as it was then. My kind of guess is that we planted them on that side because it was facing the south, so had better sun. That's just a guess on my part. But certainly planting them where they're planted now, given the condition of the forest, they have plenty of sun and they're fine. So that's a long answer to a very short question.
Got
I'm
it,
sorry.
thank you. Now, I mean, my understanding in general is, the first thing you do is you put it on your property just because it's more practical. But wouldn't that block more light from going over to the neighboring properties the closer you put it to the property? I mean, usually the way the light would work is it would project and it would have a larger ability to spread out.
Yeah.
If it's further away, so the closer the obstruction would be, it would probably stop that lighting closer.
Yeah. I think the key to landscaping of something like this is an office building that we've constructed. So you're not trying to screen the building, but what you're trying to do, in my opinion, you're trying to screen the parking, the vehicular traffic. I think it serves a better purpose of all of that being on our property. I will tell you, since you've talked about lighting, there were some lights on the back of the building that were mounted. There were floodlights, and I directed my client to take them off, made cutoff fixtures. So that was part of when we finished construction. My company does an as-built survey, and there were questions raised by the Township engineer, T&M, during that process. And as part of that process, they asked about these lights. I researched the approved lighting plans, saw that the light fixtures in the back of the building were not matching the approved plan. So those were fixed voluntarily by my client before, just since you brought up lighting.
And my last question was, I mean, before you said that you actually planted them, I wanted to maybe propose if I don't know what the HOA's opinion is, but if the issue from your client is, from the applicant, is possibly, liability or, putting something in someone else's property, hitting other lines, would there be a possibility of having a escrow and you contribute to that escrow and have the HOA take responsibility for actually planting them, but it would need some kind of a stipulation that it needs to be executed by a certain time in order for you to get your CO?
I think there's many, that's certainly a mechanism for us to plant the trees on their property. Never done it before, but I agree with you. But it just seems very cumbersome for something that should be a simple landscaping buffer.
I'm just trying to understand why it was done that way, and if we wanted to make it work that way,
Yeah,
there is a way to do it, so.
I can only think that 2008, we weren't thinking that far ahead.
All right, thank you.
So I will admit, I was a little taken back when I saw that they were, can you hear me? Okay. I can't hear myself, so I was a little taken back when I heard you say that they were originally supposed to be put on their property. And
Yes.
the first thing that popped into my head was liability.
Exactly.
What if something falls? What if somebody gets hurt? Who then is responsible for something like that if something was put up on the 3 Pence property? Maybe I'm overthinking. I'm an
No.
accountant, I overanalyze.
No, it's,
You know, that would be my concern, so it would make more sense to me that they would have been put on your property.
Right.
Anyone else have any other questions, comments? You're good.
Maybe I didn't hear at the beginning, but did 3 Pence approve the trees being planted on their property?
Mr. Borden? Went back in 2008.
Uh,
I mean, they had to give
there's
approval
nothing in
for
the file
somebody
that
to-
says they approved them. What the resolution talks about, actually has a statement in the resolution verifying that multiple residents of 3 Pence appeared at the hearings and objected to the application. They certainly were objecting to the application back then, that's clear, and I recall that very much. As far as did they ask for the trees to be there, I do not recall. I have to believe they did, otherwise we wouldn't put them there, right? I've never and I've done this, unfortunately, some days for 40 years. I've never planted trees on somebody else's property as part of an application. I've never done that before. So the fact that they were done in this case, without me remembering the details, tells me they had to want them there. But there was no mechanism put in place
Yeah,
to allow us to plant them.
yeah, and we can't have that as a condition that somebody's going to do something on someone else's
Right,
property.
exactly.
So it's logical to assume that at that time, there were people from 10 Prince to, gosh,
3 Pence Brook.
thank you. I was like, that doesn't sound right, but I know what I mean. Present, and that they had indicated that they wanted that, but it was not memorialized, their participation, and they're saying that was not part of the resolution, it's not part of the record that's here, and it's not a proper condition for someone to do something on someone else's property.
So there's no paper trail for the trees?
Certainly, I have not seen any, and it sounds like Mr. Borden has not as well.
No, never have.
I'm sorry. Any other questions or comments? Mr. Pfeffer, would you like to say something before I open it to the public?
I agree with everything Mr. Borden says. In addition, I just wanted to point out that there would be, even after they got the CO, there would be a maintenance bond, and which would then cause another issue. Should those trees die later on the other property, we don't have control over it, and it just causes an ongoing issue. So I reaffirm everything Mr. Borden indicated, and that's it.
Mr. Peters, Mr. Romar, comments or concerns before I open it to the public?
It would just be my opinion that this would be not a typical situation to plant on an adjacent property.
All right, we're going to open this to the public. Anyone wishing to come forward and comment on what you've heard this evening, please do so at this time.
Good evening, everyone. Bonnie Wright. I am an attorney at Hanlon, Lehman and Wright.
Excuse me one
Oh,
second.
sorry, could you spell your last name for me? Yes, W-R-I-G-H-T. Thank you. You're welcome. Again, I'm an attorney at Hanlon, Lehman and Wright in Freehold. I represent various homeowners in 3 Pence. I recognize that it is an unusual condition of approval, and I appreciate that the board recognizes that there are liability issues and things that come from this. However, there are various concerns of the homeowners, specifically the ones that abut this property, and that map doesn't accurately deflect actually how many units actually abut this project. I do have some photographs that I would like to share that show exactly how close this project is and what was testified to in terms of what woods exist that suggest that there is some actual still existing buffer between this project and the 3 Pence, which is nil. I've also got some photographs that will depict the plantings that the applicant has made because they purchased them and they were going to go bad, and I understand all of that, but they also provide absolutely no buffer at all. So again, I appreciate the logistics, but I'd like the board to take a look at these photographs. My client, Ms. Anderson, is here to testify that she took these photographs, and she took them days ago. I'd also like to point out that, in my opinion, and again, recognizing the unusual nature of this particular application and the landscaping plan, and providing that landscaping is put on other people's property, I question the board's authority to approve this as an administrative decision. In my opinion, it requires an amended site plan application with notice to all property owners so that everyone can show up and express their opinion on this. So I would like to call up Ms. Anderson just to testify to the photographs, which I'm going to give to Mr. Pfeffer, because of course he needs to see them first. Actually, there are a few more. I'm going to give you this. Again, I did not detach them from a letter, so for just going to have you look at this. Let me know when you've had an opportunity to look at them.
If you just bring up the person who took the pictures,
Yes.
qualified, just confirm that they're the one that took the pictures, the
Absolutely.
date they took the pictures, and that they were not edited in any way. And with that, I would have, assuming they
Happy to do that.
testify to that, I have no
If you
objection.
haven't testified to that before, I hand them to the board member.
Yes, please.
Yeah, we can't, yeah.
I'm sorry. Okay.
Yes, if you could have them qualified before they were submitted. Thank you.
If she's going to be, your client is going to be providing testimony, I'd like to swear, her, please. Do you swear the testimony, information, and comments you're about to present for the board represent the truth, the whole truth, and nothing but the truth?
I do.
And would you please state your name and address?
Megan
for the
Anderson.
record?
MEGHAN.
Should I at least give these to the secretary so that she can mark them as I go through them, and then I'll pass them out to the board?
Yes, you only have one copy?
I have 11 copies, but he would like me to have her authenticate them before I pass them out.
All
But
right.
it's going to get a little bit confusing in terms
Okay,
of marking
so-
the exhibits.
Mr. Weber, are you agreeable to have it marked at this
Yes,
time?
yes, that was,
That's fine.
Okay.
What we generally done with objectors' photos, we would go 01, 02, 03 with today's date. So if you want to go through each one, I can mark them on my set.
Okay, so I'm going right where you start. Okay, so we're going to mark this 01. Ms. Anderson, I'd like you to take a look at this photograph that I have.
I'm
marked.
sorry, if you could just speak into the microphone, you can tell the acoustics stink in here, so if you could just, if you have to yell, yell.
I can always hear myself. Ms. Anderson, I am asking you to take a look at what I have marked 01. Do you recognize this photograph?
Yes, I took it
Do you recall when you took this photograph?
many days ago because there's snow on the ground.
Can you give me an approximation? Was it 10 days, 30 days?
Maybe 10 days ago. I would have to check my phone.
Okay. And where are you when you're taking this photograph?
I'm standing to the left of my fence.
Okay, and I see that there seems to be some type of measuring tape in this photograph.
That's correct.
And what exactly are you measuring in this photograph?
So I measured to my back of my fence to one of the bushes that they planted, and it was under 100 feet.
Okay. And when you say they, you're referring to the applicant?
That's correct.
Okay. So now I'm going to show you what I have marked as 02. Do you recognize this photograph?
Yes,
Did you take it?
yes,
Do you recall when you took it?
probably around the same time.
Okay. And exactly what is depicted in this photograph?
This is the buffer of woods that they're referring to.
I'm going to show you what I have marked 03. Do you recognize this photograph?
Yes,
Did you take it?
I did,
Where were you when you took it?
right next to my fence.
And exactly what is depicted in this photograph?
This is just showing that there's zero buffer, and the buffer that's there are all dead trees.
Now, I'm showing you what is marked as 04, or 04, forgive me. Did you take this photograph?
I did,
When did you take this photograph?
either yesterday or the day before when I was walking my dog.
And what is depicted in this photograph?
This is another photograph of the woods, showing dead trees, and there's small bushes that they planted, but there's no buffer.
That's okay, I'll pick it up. Thank you. I am showing you what I have marked as 05. Do you recognize this? Thank you so much.
Yes,
What is it?
this is, again, the buffer of woods that are supposed to give us some privacy, and there's none.
And when did you take this photograph?
Just the other day when I was walking my dog.
Okay, all right, that's everything. May I share these with the
Can I,
board?
can I just ask one question?
Yes.
Where were how were these pictures taken? Were they taken with your phone?
With my phone.
Okay, so, because you gave an approximate date, the phone would have a date stamp of when you took it. I do think it's important to know the date that they were taken relative to when they were planted. Do you have your phone with you that you're able to check and see what date stamp they were at?
Yep.
If you can, again, and with that, I have no objection to, they could hand out the pictures. I do think the date is important to when they were taken.
Thank you, Mr. Pfeffer. All right, in the interest of time, why don't we go ahead and
Yes,
get
they could
the,
circulate it. I'm just asking if that could also be,
the photographs distributed to the board. Meanwhile, the photo will be located and the date put on the record.
What date did you take that photograph? And that would be, the one you're speaking to now would be what I have marked as, hold on, gotta go backwards. 03.
Was taken at 12:33 PM on Monday.
And
Yes, that's correct.
04,
04.
February 3rd,
Monday. this
Monday,
past
February
Monday.
3rd.
Is that this one? This one?
you keep looking while I keep flipping.
While she's searching for the date, you can hand out the photographs.
The parking lot one was taken yesterday at 1:52 PM, which is, it looks like 05.
Thank you.
All the photos with the measuring tape was taken Saturday at 1:42 PM, this past Saturday.
Which would have been February 1st.
February 1st.
Yeah, that sounds right. 'Cause I think Friday, January 31st?
Thank you.
No, I did not. I saw the email saying you were rejected and getting the correct email, but I didn't see it. Thank you.
Yeah, but she didn't say that. I have a question for the attorney.
Yes.
So you mentioned that you represent 3 of the homeowners?
Several of the homeowners.
Okay,
3 are
several.
here this evening, yes.
Okay, so my question is, I'm not familiar with how this community is set up. Is there not an actual board, and isn't all of this property that we're speaking of common, which would fall under the board, not an individual homeowner?
Well, that's actually a very good question you ask. So if you flip a few through pages to what is Exhibit D on the document that I provided you, beyond the photographs, you will see what is the list of neighboring property owners solicited by the applicant when they first made this application. And what you will see is that it is individual property owners. not 3 pence. Do you see that? Yes, Exhibit D on the packet that I gave you is a list of the property owners.
I gave my packet away, so.
Oh, I think I have a spare. Would you like it?
Right, no, I got it. So
These are the list of property owners that when the applicant made a request for all homeowners within 200 feet of the property, of the subject property, that this was what was provided to them.
why wasn't it
I'm
not
go-
provided to the entire board?
If I could-
Like,
I
isn't
could-
there a board?
So if I could just object to that statement, and Bonnie, if you can, if you look at, I think it's the first block and lot that's on your Exhibit D, which was the certified list that when my office requested, it was received. The first one is Block 5601, Lot 59, 3 Pence condominium. 1 Willow Pond Drive, Howell, and if I had to guess, if I went to my office and went into storage and got the certifieds, I could almost guarantee you, because I see these check marks, I'm assuming you got this from the board, if you put an Oprah request in, I'm assuming that they went through each of the certifieds and checked it off. So the association was notified, they were on the certified list. So I just want to make sure to clarify, the record is clear that, yes, them, and then along with everyone else that's within 200 feet. That's who got the list, and the applicant would have been required, as is the same law today, you have to rely upon the certified list that comes from the township.
I'm not disputing that and not suggesting they did not do what they're supposed to do, and I agree that the association was served. The question was, wouldn't they be the ones that would have the right to respond? But you will see the majority of the people that are on this list are specific and individual residents of the condominium association.
Right.
On Schilling Way and Colonial Court, what is noticeably absent is Forge Court, which is where my client, Miss Anderson, resides, which is less than 100 feet from this property. And in fact, if you see now there's 3 buildings in a row, that's Schilling, and then the one over to the left, that's Forge Court. That's where Miss Anderson resides, the one closest to the bottom. So when she looks out her back door, what she sees is that building. So
So-
let's return to the photographs.
And to be honest with you, I'm not disputing any of that. What I'm trying to just get to whether we're not, in fact, wasting any time when all of these areas you're speaking of seem to me as a common element. A homeowner doesn't have the right to, regardless of what's on a common element, when it's a part of association. It's an association board issue, not an individual. So, for example, an individual can't plant trees, bushes, anything on anything that's considered common without board approval, likes or dislikes. So I'm not disputing the placement of the trees and where they happen to land, where the homeowner lives, but does the homeowner actually have the right here or there to even bring this application up when it's an association, when there's a board involved?
They own their property.
Oh, so they do, that's what I'm
They
asking.
pay taxes, so you were right,
Well,
there's
no, no.
common area.
No, I understand.
But the area, the townhome that they own, and the area out back, which is their little patio area, they own it. And they they are entitled to notice as a matter of law, and unfortunately, for reasons I don't quite understand, other homeowners, for instance, Ms. Anderson, my client, who's here tonight, never got notice of this initial application, even though unequivocally, she is less than 200 feet from the property. So do the individual homeowners have a right to object to an application that is within 200 feet of their property, or in fact, anywhere in the city, in the town? Yes. So the fact that they live in association doesn't negate their right to come to this board and speak to them about how this project is impacting them. Now, again, this project is built. We're not here to object to that. We're here to talk about the landscaping and the need for the buffering. So, did I answer your question or no?
Yeah, I'm just you did, I'm just unsure of the way. So, for example, I'm president of my board over in Cooksbridge. Every homeowner has a deck. Every homeowner has a driveway, but it's still common. They don't have the right to do anything that is part of a common element inside of an association. So they have the right to speak if they don't like anything, but it's still a board decision. So
But
that's
I
where,
just, maybe you and I are miscommunicating.
we're not.
Because they don't have a right to say, yes, plant the trees on common area, or no, don't. So if that's the point you're making, I would agree with you.
Okay,
It does not impact their right as tax-paying residents of Jackson Township, who are entitled to notice, and in this case, were deprived of it, to object to a modification of site plan approval without the appropriate protocol being
Okay.
complied with. Okay, so I'd like to go back
I'd just like to
to the,
continue on that. The board, the HOA is still going to have the final say on the planting or lack of planting or remediating the ground or whatever. Shouldn't they be represented at this meeting?
well, since
the
it's
homeowner
interesting, you
can
should
come
ask
up-
that
the
question,
homeowner can
because the
come up
president
and-
of association is here.
Wait, hold on.
Stop, we're not getting a good record.
Okay, the homeowner can come up and present their case as they are, but the homeowner association should also be here and have their attorney present to help make a decision, because the final decision is going to be from the homeowners association.
I'm not sure why the homeowner, again, we're here, my clients are here to object to the modification of a site plan approval not following the proper protocol.
Okay, so if I may, I feel like we're getting a little bit far afield here. So this is what came in as request for an administrative approval. The request was to change the condition, because the original plan of having the buffer planted on the property of the association was improper as far as we can prove at this time. So there was a request to move that buffer simply onto the applicant's property. The engineer had weighed in and found that that was not substantial, that it was appropriate as an administrative approval. The question is, if you want to allow it just to be moved on to the property, it's going to be taken off the HOA's property, away from the resident's property, and onto the property of the applicant. The question that is being presented is whether that then would require an amended site plan and an opportunity for full notice. And Mr. Pfeffer is correct, he got a certified list, he's entitled to rely on that list. However, there is testimony that's been provided that there are people within 100 feet that did not receive it, and as the members of the board have said, the HOA itself is not represented. Now, they cannot be forced to be present, and they do appear to have received notice. So it's not a question for Ms. Wright and her clients to produce the board or force the board to participate. The question really before the board of the HOA. The question before the board right now is really whether you want this to proceed tonight based on the request for an administrative approval, and I'm going to throw that back to Mr. Romar when he's had the opportunity to hear, and I'll let Ms. Wright continue, but I just wanted to sort of refocus and sink down in my chair really low. That's the question that's before the board now. It was an administrative approval, it had been approved that way. We're now hearing that there may be interested parties that had not received notice. We said the HOA board is not participated. They do appear to have received notice from the list, and we cannot compel them to come forward if they do not wish to.
I just want to be clear, that's the notice from 2008 when the application went in. Just so I can be clear that that resolution and then what was attached to the opposition's letter, I'm talking about is all notices from 2008. Just want to be clear.
And through the chair, excuse me, through the chair, Because the list is being discussed, we call that 06.
It's just, it's part of Ms. Wright's letter, so if you've already marked her letter
They
as...
only marked my photographs,
Oh,
Adam,
no
not the,
problem.
yeah, because the letter I don't think is permissible. So
Not a
it's just the attachments.
Not a problem.
I'd like to go back to the photographs, and thank
Sorry,
you.
hold on
Sorry.
1 second.
Just
Yes, Ms. Parham.
quick question to our attorney. For an administrative approval, notice is not given, is,
That's correct.
Right.
okay.
And I just asked Mr. Borden, he indicated he did send copy of the...
When I met in November, I met with Stacy, who's a representative of the board with the management company, and I've been in constant contact with her. I had notified her of this hearing via email. So I've been in constant communication with the board management company.
So let me just be clear. You said you spoke with Stacy at the management company. Is that the homeowners association or the management company?
She represents the homeowners association. That's, okay. When I asked for a meeting with the homeowners on the site, she is the one that attended. I don't pretend to know their management structure. I asked for the homeowners to meet me, she met me.
Through the chair?
Yes.
Just for the attorney, I just think I'm missing something. In your opinion, does this require an amended site plan and require notice, or does it not? And we're debating whether they should have noticed or they shouldn't have noticed.
Right, the application when it came is appropriate. However, at this point, I think that given the notice issues and the need to make sure that, because it's not just at this point a question of moving what was approved onto the site. There certainly is there are interested parties that are expressing concerns with that. I don't know that it can be done as administrative approval. Mr. Romeyer, has your assessment changed given that it's appropriate for an administrative approval, given the information that we've received?
So what the proposed
Microphone, please.
Proposed changes from the original plan are typically handled by administrative approval for moving the landscaping. So that was my original assessment, and I would defer to the board members if they'd like to discuss and vote on it.
If I can. So we have no objection to obtaining a new certified list for everybody within 200 feet and sending it out for the same administrative approval. I do not believe that an amended site plan is required. As you heard testimony from Mr. Borden, that the site is fully developed. They are close to obtaining the CO. The building, there's no question as to the location of the building or changing of the building. There's no question as to the roadways, the parking area. All of that is staying. The only question is now the location of the trees, which, when I heard some of the testimony, a minute ago, comments from the objectors, they're saying that, it's not enough buffering. The buffering isn't changing. We used the same type of trees. It's just a matter of that we planted it on our site versus planting it on the association site, which, as all the comments I heard previously, there are concerns. But again, we have no problem tabling this, getting the list, sending the notices out, and seeing what comes out. But I still believe it should be done via administrative, and no amended site plan that should be required.
I would like to be
Pfeffer, and-
heard before,
I'm sorry?
I'd like to be heard, if I may, before the board makes a decision on this.
Absolutely. Hold on just
Okay.
1 minute.
Fair enough, thank you.
Mr. Peporo, not to put you on the spot, because I'm sure the answer is you don't know, because this goes back how many years? I'm just a little confused. The list, I understand it's from 2008, but how was this not picked up then, that they didn't notify everybody? I know
Well,
that the-
again, the applicant is relying on the township to give them the list that the township produces, and this came from the clerk's office. There would have been no reason to double-check what the clerk's office offered. So the applicant relies on the list that's furnished to them.
I'm just curious as well, like, will the new list be different than this list? And are there more
are there more residents that are saying that they also weren't on this list, or is it just Ms. Anderson?
If I may, to answer that specific question, I'm going to ask you to flip to what is Exhibit C on the package I gave you, which is basically like an aerial, informal map. And we'll mark it, where are we, 07? And you'll see the red dot, which is where Miss Anderson's property is. And again, the photographs, which I'd like to go back to because you guys didn't have them when we were talking about them, is less than 100 feet. So again, she's in that sole brown building, brown condominium, looking at the building. And so you can see where I've circled this. There are other buildings on Forge Court. There are other buildings on Colonial Court. There are certainly other properties that should have been noticed. And I just want to be clear, in no way, shape, or form are we insinuating that the applicant did anything wrong in this regard. But absolutely how Block 74, which is the applicant's property all the way to the left, did not include these property owners, not just the association, on their notice is very problematic. Because you did, and I'm sure none of you were here then, maybe some of you, but in the original application, there were homeowners that showed up complaining and objecting to this application. There would have been more had proper
I object to
notice
that.
been served.
You don't know that that's the case. And again.
It is
The
speculation.
association, we've already heard testimony from Mr. Borden. The association was noticed. Additionally, there were 3 meetings apparently, and there were multiple residents from the community that came out. So to say that nobody knew about it, I'm sorry, you can't say that there would have been more people or less people.
I didn't say that nobody knew about it.
We're not going to revisit the propriety of the approval from 2008.
And I'm not attempting to do that.
And I also, if we're going to end up doing this again, I appreciate you and will certainly have you be heard on the issue of whether the proposal made by Mr. Pfeffer, and I will then advise the board, but I'd like to give you the opportunity to be heard first. Right now, the only question that I'd like to see addressed is whether it's appropriate to have this a noticed administrative approval, where Mr. Pfeffer will get a list. To your question, Ms. Brennan, it would go to the tax assessor's office. That will be the list. Presumably, it will be a full and complete list as of 2025, but Mr. Pfeffer will be able to rely on whatever that list is, and then come back again for the administrative approval, or, Ms. Wright, I know that you have suggested that it needs to be an amended site plan. I'd like to stick on that issue, because if it's going to come back, and there's going to be testimony before the board, one way or another, at another hearing, I would rather have that hearing at that time, have that testimony at that time rather than have it before the board twice and piecemeal.
I would like to revisit the photographs now that you all have them, because quite frankly, while I do not think this is the appropriate process to hear this application, my client's main concern is the fact Mr. Borden previously testified about the lighting, and I appreciate that testimony. But the fact of the matter is, it was my client calling and going to the township daily about the football lights shining through her bedroom door.
I'm going to object. We're not
that
here for lighting.
resulted in those
We're not
lights
here
being
for
removed.
lighting.
Ms. Wright, I don't feel that I'm making myself clear. I understand there are things you would say. Do you want to be heard on the issue of whether it needs to be an amended site plan, or do you want the board to move directly to consider the request made by Mr. Pfeffer to allow this to be a noticed administrative review at a later date?
I would like to at least review the photographs, and then I will speak on that issue.
Okay, well, I'm asking you to speak on that issue now.
Again, our objective is not to necessarily inconvenience the applicant. So I feel as though if you would let me go to the photographs, perhaps I could get to that without the inconvenience that this would derive.
All right, well, that was a very tempting offer. So, we'll proceed
If you're
on
not
that
inclined to
basis.
let me do that, absolutely, it is my opinion that they have to file for an amended site plan. The landscape plan was part of the approval in 2008, was incorporated into the resolution of approval, and as such, if they want to amend that approval, they need to seek amended site plan with notice to all property owners. That is my position. Vice Chair, that's a great point. I did submit this in advance, and I was advised this wouldn't be circulated to you. I also was not advised to submit these by a methodology that they could go back on the big screen, because I certainly would have complied with that.
Hey, Ms. Wright, I'm confused, because you suggested that you wanted to spare didn't want to inconvenience the applicant.
And I don't.
But you also do want them to do an amended site plan.
No, you forced me to take that position when I asked you to permit me to go back to the photographs.
Came across as facetious when I said it was a tempting offer. If you have a way to proceed now and take us through the photographs that could resolve this matter without the necessity of return, I think the board would want to hear that. If that is not the case, then I think they would want to make a decision on how this matter will proceed in return. Is it possible?
Understood. And the reason I want to go to the photographs, do I have an absolute resolution? No. I want the board to see it and the applicant to understand our position, and perhaps we can come up with a resolution. I want the board to understand what my client's concern is. The applicant has asked you to remove the plantings on another property, and again, I fully understand that issue. I get it. They have planted what they were, at least what their testimony is that they have planted the plantings that were approved on the initial resolution at the original application on their property. But if you look at the photographs, those plantings are not sufficient. That picture depicts plant that would suggest real buffer. But if you look at the picture noted as 04, let me just make sure I've got the right one. Yes. Actually, if you just take a look at 03, this is what my client, Ms. Anderson, sees when she looks out her back window, which she did testify to that, so I'm not speaking for her. So it's pretty large. When you go to 04, if you look through, as I think Mr. Borden testified, what used to be actual woods is now decimated. I'm sorry. Yes, because you weren't there. So if you go to the first photograph, that's 01. So you can mark them just so you can follow along, which has the tape measure. Okay. 02, which again is a bunch of leaves, tape measure. 03, little bit of fence, big building. 04, more woods, if that's what you want to call them. And in the background, tiny little tree. So this, Ms. Cipriani, is why I wanted to talk about this, because these are the plantings, as my client testified. She took these photographs a day or two ago. This is what has been planted. And if you see all the way to the right, there's another one of these plants. This is never going to be sufficient buffering for this residential community. So again, unfortunately, do I have the resolution as I stand here now? No. Do we want to inconvenience the applicant? No. But if the only way that perhaps my clients, and other residents of this community can get sufficient distraction from this is to force an amended site plan, well, then that's what I'm requesting you do. But that's not really the objective. That's not why I'm here. I'm here to let you see what it is that they're dealing with. Again, look at 05. Look at the distance between the plantings that allegedly are taking the place of the plantings approved on the landscaping plan, approved with the site plan. They are far and they are tiny. It's not enough. So I'm asking, is there some resolution that can be made to make this less imposing on the residents? And if there isn't, and if the applicant isn't willing to make some concession, then yes, we're going to have to go back through this all over again with proper notice to all of the residents who can express their position on this.
It seems like all of this discussion around the photos is really contesting, number one, whether what was approved is sufficient for the objective of privacy for the neighbors or buffering, and number two, is what they planted, I guess, does it match and is it in compliance with what was approved? My question is, the discussion around noticing, is that of concern to you or your clients? Because I think that's the matter that there's two matters that were brought up, is were there enough people, what was everybody noticed, and is it appropriate for this to be administrative approval versus amended site plan? But the discussion around the photos doesn't seem to be really talking to those 2 points. So I guess my question is there concern around notice? I understand there's concern around the administrative approval. Is there concern around notice about this? Like, I just feel like we're going all over the place here.
Well, I would agree with you, except again, I was specifically asked if there is a resolution that can be reached without requiring that. And that's what I'm speaking to right now. I'd like to go back to the approved plan. Do you have that on your thing?
Sorry, just to clarify, so are you suggesting that if the applicant would make Ms. Anderson and, whoever else you represent happy, then notice wouldn't be an issue?
No, I'm not, I would like to see the approved plan. What I know that on the approved plan looks sufficient, and that is not what they're living through now.
Exactly. So I think what Ms. Wright is trying to say is, if they could come to some resolution about the plantings and what is there and the buffer, then I think, and you can correct me if I'm wrong, what she's saying is we can put the issue of notice to the side and come to some resolution to make the residents as well as Mr. Pfeffer and his client happy. Am I understanding you properly?
I, Ms. Parnes, am not suggesting that what was approved wasn't sufficient. In fact, I think it was sufficient. But they don't want to do it for potentially reasons that I understand. They are now trying to modify that approval. And that modification will result in real inconvenience to the residents of 3 Pence.
What it sounds like you're suggesting is that what was approved is sufficient, but it doesn't match what they did, and what they're claiming is complying with what was approved.
That's not what I'm suggesting. What I'm suggesting, I believe, and that's why I'm asking that for the approved plan to go up on the board, it was probably sufficient. But what it doesn't appear is to match the photographs I'm showing you, because they have testified that the very plantings they were going to put on 3 Pence, they have now put on the subject property. And I'm showing you what that looks like. And it is not sufficient. So am I maybe questioning that the number of trees and the type of trees that were supposed to be put up originally were not installed? Maybe. I know this is what they look at when they look out their back porch or their bedroom window.
Madam Chair?
Yes, Mr. Bresson?
Yeah, I think I'm understanding what you're saying, and I'd have to throw a question to Mr. Borden. Looking at the drawing and look at the pretty green trees, different shades and stuff, then you look at the picture. They don't match at all. Like, what was approved, to me, just doesn't look like it was ever put in. Or they died in between or something. So this picture they're showing us, then it's not complete then?
What we're talking about here are proposed plans.
No, you said that, no, your
Yes,
testimony, I'm sorry, forgive me,
I think I can
Shira.
clarify.
His testimony, Mr. Pfeffer, just so I can get this on the record so we're all clear. His
planted.
testimony was that they were already installed because they were
Yes.
going to die.
Yes.
Because they were purchased, which we
Yes.
can all appreciate.
If I could ask a few
So were they installed or
questions.
were they not?
No, they're in. Mr. Borden, the plantings that were approved back in 2008 as part of that approval, first, are these the same species of plants, sizes that were installed on the applicant's site?
The proposed planting plan that this board is considering is the same species and size.
As the one from 2008?
That's correct, at the same spacing.
And were they planted?
I do not know.
But
I've
somebody
represent,
correct me,
we have
excuse
the
me.
answer.
Maybe I got it wrong. You guys know I take notes, so maybe I wasn't paying attention. Was it not stated that they were planted?
Yes.
Yes. I just spoke with the representative of the applicant. They've confirmed. The same trees that were ordered were planted just on our side as opposed to planting it on their side. They were planted.
Okay, so then please, if I'm speaking out of turn, please correct me. Then I would have to agree, based on the proposed plan that was to be put on their property, to what you've done on your property does not match.
Respectfully, the picture, if we go to, I think it was, sorry, A3. So again, the picture is a picture, it's not trees. You have to go to the specifications that were approved in the landscaping plan. And our representation and our testimony is exactly that was what was approved in 2008, was planted, just not on their site and on our site. They may not be happy with what it is, but that's what was approved. We're not looking to change, meaning if the board says, no, you got to go back and do it and move the trees, they're going to end up being on their site. It's not going to be more trees, it's not going to be different height trees. It's the same trees that were approved, the same landscaping plan. Trees,
Mr. Pfeffer,
bushes.
would you help me out here, please? Would you agree with me, though, that what is portrayed on this plan is not what's in these pictures?
You don't have heights and
No, I'm
descriptions
not
for each
talking
of
about,
these.
I'm just talking about number. I'm not, forget heights, I haven't even gotten there. Let's talk about number of.
This is a depiction. I
I'm
can't
sorry,
tell
Ms.
you.
Barnes. Mr. Pressley, spacing,
I think I'm going where you're going, too.
please.
I look at these pictures, they look nice and pretty, and Ian puts them real close, together.
There's too many people talking.
The applicant shows all the shrubbery close together, so forth, looks real pretty and solid. But yet, when you look at the picture, look how many feet apart they are not solid.
I understand
There's
that.
nothing there.
They're also, if I had to guess, if I had asked Mr. Borden, they're probably depicted as fully grown, bloated, they were just installed. But if we go
Fully
back,
grown-
but if we go
fully
back,
grown?
if we go back, if we go back to the plans and what their heights are and what the amount of, the testimony is, you're going to find the same exact numbers that was approved in 2008.
I don't know how wide these bushes grow, but I can't even imagine them growing wide enough to fill in that gap. No way.
So, so just to go to the next step as a practical matter, should this go forward and we say, you know, fine, we'll pick them up and move them, it's the same plantings, it's just going to be on their side of it, and we have the same then issue regarding can we do it, how we do it. But that's a separate issue. Well, we're not here saying we're going to, if we go on their side, now we're going to put another extra 100 trees.
Through the chair?
Hold on, I'm sorry, Mr. Hudak had asked to speak, forgive me, go ahead.
So,
Microphone.
the drawings that you guys have supplied, could we go back to the original plantings? Is that A1? A2, okay. So this is what you guys said you were going to do, correct? Back in the day, back in 2008, yes? Yeah. Okay. So we have 17 years later, okay, we have photographs that, you know, you would think that you guys have those lined up that you wouldn't even be able to see through them. So 17 years later, you would think that these trees would mature and everything would be nice, right?
They were planted
never planted.
They were planted a couple weeks ago. Yes, they were just planted.
So-
Madam Chair.
So these were never planted?
Correct.
They
I
never-
thought you guys planted them on their property.
No, they
No,
never
no, this-
planted them on their property.
No, the building was just
That
constructed.
was only the proposal.
Correct.
The approval was in 2008.
I got you, okay.
It
I'm
did not
sorry.
start until,
I misunderstood, okay. Apologies.
Right.
Apologies.
Right.
Got it.
Madam Chair,
Mr.
so
Oh, wait, I'm sorry, Jay, hold on one moment. Mr. Hyman?
Thank you. If you look at the two plans, the plantings of the original one has 100 green plantings on there, and the new one has 69. I just counted them. So that's a very large discrepancy between your original and what you have now. Now, what we didn't address is the maturity of these greenery, if that is compatible or if it's, the same. So if you can, elaborate on that point, I appreciate it.
Was that, okay.
Yeah, that's a question for you because.
That's fine. We put the trees, we moved the trees in the approved location to the proposed location at the same species, the same height, and the same spacing. The trees are 5 to 6 feet high, evergreen trees, planted approximately 10 to 12 feet apart. All we did was move them from one location on the plan to the other. The reason there's fewer trees is the distance is shorter, because rather than work around the outside of the arc, now we're working around the inside of the arc. The closer to the building you get, the lesser distance to cover the same cover.
Okay,
Okay,
so
Mr.
that you're not
So
proposing
the trees are
an
planted
identical.
at 10 to 12 feet apart.
Was that the original proposal? Because it's definitely not the same. Being that the
A3,
distance is.
A3, which is the next one, Anthony, proposes the trees at the same spacing, the same, that was all my testimony is, it's the same buffer. It's the same spacing as the approved trees.
Okay, now also the difference between the two plans I see is you have, on the original plan, it was every other one is a different species, and on this one, you're having different sections.
That's a change in landscape design that's occurred in the last 15 years. Back then, we used to like stagger trees a lot, and now we cluster similar species together. That's just the difference. I could,
Okay, so
I
when
could
you-
spread out the species if you want, but they're the same species, they're the same size, they're the same spacing.
Not a problem. We just shouldn't be saying that we're proposing the exact same thing. We need to be clear for the record that we are changing that plan. We are putting in fewer trees.
There are fewer
but
trees.
But it is properly spaced, so,
The same spacing or fewer trees because the distance is less.
thank you.
Through the chair,
Such?
just something quick now.
All right, so,
We know what the applicant
into
is
the microphone,
proposing.
please.
What does the, okay, sorry. We know what the applicant is proposing. What does the opposition want them to do? And let's see if we could come to an
But before
agreement
they answer
between
that
them.
question, Dr. Hofstein, I need to go back to picture number 4 and to talk to Mr. Borden a little more. Oh, I thought Mr. Pfeffer had, I thought Mr. Pfeffer, yes. 4. So you said that they're 10 feet apart. And,
See the trees from my map planted in this picture. These are the trees that were planted, the original proposed landscaping on the property had more scattered, smaller trees. So I don't see this is the very back of the parking lot. This is not behind the building.
My client testified that this was taken a day or two ago.
I'm not
right, so
questioning
that
that.
number 4, according to the resident, was taken midday on Tuesday, yesterday.
I'm not questioning that. I'm just
No, no,
saying that
I understand. Give me
if
a
you
minute
look
to
at
ask
our
my-
plan, I can't,
Please give
I
me a
haven't,
minute to ask my question. Thank you. You said that they were approximately 10 feet apart. I'm not going to discuss height. They were just planted. I can't discuss height because they haven't had a chance to grow. My concern here is, as a homeowner and a resident, how do you ever think this is going to be a sufficient buffer? I'm sorry, I can't consider that a sufficient buffer.
you're assuming that I believe this is my plan. I don't believe this is my plan.
Madam Chair?
Yes,
What I see here is inconsistent with that plan that we've presented. If you look here, this picture is in this corner right here. Look
you
at
have
those
pictures?
trees. Look at those trees. Those circles, those green circles and
Yeah.
darker circles are 10 feet apart. I don't see that here. So that tells me, I haven't been to the site. So
Well, that answers my next question.
I was gonna say,
That answers my next question.
I am trying to get a proposed plan approved, that is this plan. I'm not here to testify that this was planted.
But you were
I have
saying
no
that-
idea if this was planted.
But Mr. Borden, you said that they were already planted, so I need to know, before this board, not just myself, before this board can decide if we're going to move forward, if they're already planted and you're saying you're not planting anymore,
Yes.
how can you expect us to vote on something that doesn't match your plan?
I've seen this part of
And
the
you just said
site.
you weren't at the site, so you don't know if it was planted the
I
way it
have
was
seen this
supposed to.
part of the site. I've not seen the back of the parking lot.
If
Mr.
I
Romar,
may,
Excuse me
One of
one
the-
second,
one-
Ms. Wright,
so
I'm sorry. Mr.
If I could
Romar,
just, sorry.
I just wanted to point out, typical procedure would be for the board to approve a proposed plan, and then once the construction's completed, the township engineer is responsible for inspecting the improvements to make sure that what was constructed is in accordance with the plan. I would advise the board to focus on what is proposed on the plan, and less on what is shown in the pictures. Because
That was going to be my next question. What we've indicated is, while we've planted them, everything that came, if the board does approve it, when they come out for inspection, if this is not consistent with what was approved, we won't get our CO, and they will have to add the additional trees. We're still here. It just happened to have been that the trees were ordered, and when they had a practical issue with regard to planting the trees on the other property. So they planted them on our property. If the board says, yes, this makes sense, what Ian has proposed is what's good. If that's what's approved, the township engineers will be inspecting that. If a tree is missing, 2 trees, 10, 50 trees are missing, they're going to come. We're here for the main issue. It's an additional item. We've already planted trees. Okay, that's on us. But if the board approves it, we're asking to move the location from their site to our site. That's the main thing we're asking, or the only thing that we're asking.
So, Mr.
Chairman,
Morwart-
Chairperson, if
Yes,
I may just
please.
ask Mr. Borden one question. He testified earlier that he had not really gotten a resolution in terms of the position of the association, but I would like to ask him if he received the letter from the association attorney dated January 10th, 2025, making their position perfectly clear. Again, I can't present testimony on that because I don't represent the board.
I assumed the attorney would be here for the association, so I didn't realize that I was going to interpret the association attorney's letter.
So it's
But
okay to
pl-
misrepresent
please
that
allow
you
me
didn't
to
get an
read it.
answer?
I haven't read it, honestly.
All right, we don't have that letter?
If I may, for
I mean, I don't even know how I got it.
I'm not submitting it as an
I'm sorry,
exhibit.
just for a minute. I feel like the board, you know,
I'm being sandbagged here, and I'm not copied, I'm not anything.
The letter's
thank you,
directed to
Mr.
you.
Borden. Thank you, Ms. Ray.
It is?
As far as
Oh.
what the board has to decide right now, we've heard, things all over the place. One thing seems to be clear is that we're not prepared to make a final determination tonight. So there's been a question about whether it should be an administrative approval, and they should come back for the administrative approval after additional notice, or whether there's need for amended site plan. The board should be aware that for an administrative approval, that a change in location, facilities, or improvements may be approved administratively by the board upon petition of the applicant or at discretion of the township engineer, unless that change of location impacts the subject matter of a public hearing or substantially changes the location of a facility or building beyond the content of said original approval. So I think you could, based on that, proceed with either an administrative approval, give that an opportunity, or just ask for an amended site plan. My suggestion and question is there anyone on the board that at this time wants to make a motion either to require the administrative approval to return with full notice as was originally requested by Mr. Pfeffer? That'll give the opportunity for the board and its attorney, if it wants to be heard, because Mr. Gordon is not the only one that does not have this letter. So this board had indicated a desire to hear from the other board. Apparently, the statement has been made that we're unaware of. So either way, on the notice issue, I think that it would be appropriate for you to proceed with the administrative approval based on the representations that have been made, if that heightened notice or the additional notice was provided. I don't know if anyone on the board wants to make a motion to that effect.
I'll make that motion.
I second that motion, especially with the notice. That's like, has to be done this time.
Have the motion include what Gene just said. So,
All right, we have a motion and a second.
Just,
I'm
through the
sorry,
chair,
go
could
ahead,
you
Mr.
just
Hyman.
clarify what that motion exactly is?
Yeah,
So-
no.
Sorry. The motion is to proceed with a review of the request for administrative approval for the change in location of the trees based on full notice, 200-foot notice to be provided by the applicant.
Thank you.
So we have a motion and a second. Roll call, please.
Yes.
Yes.
Dr. Hopstein?
Yes.
Mr. Hudak?
Yes.
Ms. Parnas? Yes. Ms. Rosal? Yes. Mr. Such?
Yes.
And Ms. Bradley?
Yes.
May I, Mr. Hoot, to accommodate Mr. Hudak's request, in anticipation of that hearing, how is it that I submit things to you so that they can show up there?
I think,
Do yours. You have a card with you? Okay, amazing. Thank you so much.
Thank you.
Now-
That's right, if I may, this is my card, it has my email address on it.
If,
Thank you.
If I could just-
I saw it on there and I understood what had happened.
if I could just ask, is there a date that I could have so I could do the notices?
Mr. Purpuro?
If I may on that, only because I have to reach out to the assessor or the collector and find out why
No.
the appropriate owners are not getting, which I will do immediately. But
Just so we're clear.
they
you're
need to
asking-
correct their
No.
list. It is wrong.
Well,
Just,
let's
the
figure out
list
what
is,
that
the list is
date
different.
'cause I don't think it's going to be tomorrow.
The list is different from 2008. We concede that. There have been owners who have bought and sold. We are going to, tomorrow, my office will request the list from Jackson Township from the tax assessor. That has nothing to do with
Okay,
the
right
date
now, can
of
we
the
just ask
hearing.
Mr. Purpuro, can you have him stop speaking? We can't hear. I can't hear. I'll speak for myself.
Forge Court was there in 2008.
Mr. Pearl, what is the next date?
Well, looking at the agenda, which I believe Madam Chair has a copy of as well, I mean, March 19th has two applications. We can go out to April 2nd, we can go April 16th.
My guess is that a date in April will provide ample opportunity for you to
Absolutely.
do whatever you need to do.
April 2nd, please. We have the
April
April 2nd meeting?
April 2nd, Jeff?
Yes.
Thank you, everyone.
Thank you.
Need a motion to move it? Need a motion to move it to that date? Do we need a motion to move it to that date?
I touched it because I wanted to bring it up.
I don't know. I'm gonna find out. Like, see, I can't even hear myself. We're gonna take a 10-minute break. We'll return at 8:45. back to order. Just a few housekeeping things before we begin. Please speak into the microphone. It's very difficult here. I couldn't even hear myself, so I don't know what's going on in here tonight, so please speak clearly into the microphone. And for the record, as you can see, Mr. Hudak is no longer here. He had to recuse himself due to a conflict on the application. We do have 7.
You ready?
So we are going to move on to applicant number 2, Cardinale and Jackson Crossing number 2, Adventure Crossing Preliminary and Final Site Plan 839-2, Phase 3 and 4. Mr. Pfeffer.
Good evening, Adam Pfeffer, covering for Sal Alfieri, along with Donna Jennings. We were co-counsel on this this evening. The applicant is, as you indicated, Cardinale and Jackson Crossing number 2, Adventure Crossing. This application has, I know many of the board members here are new and were not here for the original approval. And this evening, we will be having, I have several witnesses for you, but what I've asked Mr. Borden, our planner, to do once he gets sworn in, is to give really everybody just the general approval, what happens, because this project is set to be done in stages and got approvals based upon different phases. Tonight, we're only here to amend phases 3 and 4, but I do think it's important for the board, and I'll just tell you because there's a lot of noise and comments that have been made about the overall project, and there's a lot of misinformation that's being spread around as to what's happening, as to what was approved, what is looking to be amended, and what will be approved, hopefully, with this amendment. But I do think it's important for the board, because like I said, even the board members that were here, it's not a small application, it's large, and there's a lot of moving parts to it. Additionally, before we get into that testimony, I just want to make sure, as a technical matter, that the application has been deemed complete. It has notice, and I'm just asking the board if you can just confirm that there are no issues or concerns with regard to the time of the application. I know there was some conversation regarding another ordinance, but that does not apply to this. I just ask that the board acknowledge that.
Mr. Pfeffer, I believe that, is this on? That, yes. Thank you. That Mr. Alfieri and the applicant themselves had received correspondence on January 7th, 2025 from the then board attorney on that issue, and stating that, in that opinion, that the time of application rule would prohibit consideration of an ordinance adopted after this application was deemed complete, which I believe was December 11th.
Thank you. I just asked that letter be made part of the record for the file. With that, it's specific to the site.
That request is proper,
thank you. With that, as I indicated, if I can have Mr. Borden sworn in, he'll be giving testimony as a planner only. We do have several other witnesses, but we'll start with Mr. Borden, and I'm going to ask him, once he gets sworn in and he's accepted as an expert, to first start with just the overall landscape of the original approval, and then get into what we're here for this evening.
Mr. Borden, would you stand and raise your hand, please? Do you swear the testimony, information, and comments you are about to present to the board represent the truth, the whole truth, and nothing but the truth?
I do.
Could you please state your name and put your credentials once more?
Certainly. Ian Borden, President, Professional Design Services in Lakewood, New Jersey, professional planner licensed in the state of New Jersey. I've been doing this for 40 years and testified in front of this and many other boards for many years.
Mr. Borden, this board accepts your credentials. Thank you.
Thank you. Okay. So, good evening again. So I'm going to provide first the background of the project, the history of the project. Then I will get into the phase 3 and 4 site plans that are in front of this board, go through the zoning of that, how we fit into the zoning ordinance, and then review some site design information. And then you'll be done with me. But got quite a bit to talk about on the history. This is a project that's been in the works and has been approved and built in some phases for the last 8 years. So at the very least, I will be very boring. I apologize for that in advance. Thank you, Donna. Who needs friends? We have a number of exhibits. We have A through 8, I believe, but A1 and A2, where the application is A1, and then the Murphy letter, as previously discussed, is A2. So to start with, Cardinale and Jackson Cross and Associates 2 have been working to develop the Adventure Crossing project since 2017. I've been working since it began in 2017. But some of the history is going to predate that because I have personally been working on the properties since 2006. This site, this Adventure Crossing site, was owned by 3 different property owners. And as you'll see in my story, Mr. Cardinale is the one who had the vision to put these together to form the project as we know it. So for background, we start with Exhibit A3 that's on the board. Thank you, Anthony. The property, and I'm talking about the totality of Adventure Crossing now. I'm going to talk about the total Adventure Crossing project, then we'll narrow down into Phase 3 and 4. The property's in A3. This is an aerial exhibit that's dated 2017. So we purposely presented this exhibit to show what the property was before the project began. And the property is highlighted in yellow. The road that goes left to right on top of the page is Monmouth Road, Ocean County Route 537. On the left, that clearing that you see there is the parking lot for Hurricane Harbor, obviously part of Six Flags Great Adventure. And to the right, you have Route 195 interchange with Monmouth Road and Anderson Road along the right, which is a township road. This property was owned highway commercial. Just to briefly talk about a little bit of the zoning and master plan as it existed, and frankly still exists to this day, which is what formed this effort to consolidate these parcels and create this project. All of these properties, which are lots 1 through 6, 19, and 20, were zoned highway commercial at the time, and they still are. They totally contain 286.5 acres. It's important to notice, and I'm going to go back to this when I get into the planning testimony, that one of the fundamental tenets of this property, and which has driven land use decisions and approvals in the time since 17 to today, is the fact that the 2009 master plan, in particular, created the desire for economic development opportunities in Jackson. It emphasized commercial and mixed-use development. And important is that, in particular, in describing the highway commercial district objectives, it was intended to provide for a diversity of commercial activities along major county thoroughfares. And in fact, the master plan recognized this particular area between Six Flags and 195 as being intended to be a commercial destination. So something more than just strip centers and gas stations. But they, even back in 2009, they identified these properties, and that was long before Mr. Cardinale was in the picture, but they identified this as a destination. Previous to 2017, before I worked with Mr. Cardinale, I represented the landowner in particular of what is now Phase 3 and 4, which is Lot 1, which I'm pointing at. That's these fields with some commercial in the front. And I assisted the then landowner, Mr. and Mrs. Vincigara, to develop some environmental permits for culvert crossings, and there's a stream that cuts through the property. And so that's where my work on the property began. But the Cardinale and the Adventure Crossing project starts with Exhibit A32. Anthony, if you could turn the page, please. And what we have here is on the same aerial that I just presented, you're going to see a sequence of plan, black and white site plan overlays to show the evolution of this project. So the Adventure Crossing project started with, this is known as Lot 2. This was known as the Scott property. It was owned by a estate of the Scott family. And that's where Mr. Cardinale acquired that property. And we did a we did a site plan that was approved by this board, the zoning board, for a commercial, recreational site plan, which included an air dome, which is currently existing today, the athletic fields in the back, as well as other uses that have not been built. They've changed since then. The reason the zoning board reviewed that project, it was all the uses were permitted. There was, however, a D5 height variance for the air dome. So for that reason, the zoning board had jurisdiction over the project, and frankly, that is the reason that the zoning board continues to have jurisdiction over the project that we're hearing tonight. Phase 3 and 4 is a completely conforming project. I'll get to that in a bit. But the reason we're here is because at the very genesis of the project with the air dome and the height variance, the zoning board has subsequently required retained jurisdiction over all aspects of the project. In doing phase 1, or the first development of, it's obvious when you look at this that there's other properties along Monmouth Road that were not included in the project, as well as the surrounding to the left and to the right. So Mr. Cardinale was actually encouraged to try to accumulate these properties as part of the destination that that 2009 master plan envisioned. And the properties to the right, which are lots 3, 4, 5, 6, 19, and 20, were owned by Six Flags. So we had two different property owners. Besides the Scott that he owned, you had Six Flags and you had the Vincigar family. Interestingly, completely polar opposites. Lifelong residents of Jackson Farmers and one of the bigger corporations in the country. But it shows this is not in my notes, but it shows how this town should be proud of what Mr. Cardinale did. No, I don't know anybody else who could put together a team or put these same people in a room together and come out with what we've done. But anyway, what we've done is we were encouraged to accumulate them, so Mr. Cardinale did so. And please turn the page, Anthony. Now we have Exhibit A3-3, which is a general development plan of the entire project, of entire properties, all 286 acres. This was this was submitted as a general development plan. I think it's important. I don't know that this board has seen a general development plan. They're unusual at a zoning board. The planning board sees them more frequently. But just for the board members to understand, and should you not, that for the last nearly 40 years, builders in the state of New Jersey under the municipal land use law have the right to seek a GDP, General Development Plan approval for development. They're limited to sites of over 100 acres. And the GDP is basically a set of conceptual plans developed under a strict series of rules and regulations on what those plans are required to comprise. And they're intended to be submitted to the board prior to the site plan. In other words, it's a master plan of the property, right? The town does the master plan to the entire municipality, and a GDP is a master plan for development of a property of more than 100 acres. What a GDP does is it protects the zoning of the property for up to 20 years, as well as create the footprint for what the future development will be, so that the site plans can be developed with the knowledge and understanding of the regulatory partners, in this case being the zoning board. The GDP, as you see on the board, was approved in 2019 under Resolution 2019-16 and 24. There was two resolutions. The GDP included the same uses that we had on Lot 2, which is in the middle here. But it also included 502 residential apartments with 58 affordable units, as well as commercial uses along Monmouth Road, including fast food and convenience store, as well as Top Golf and other commercial, as well as apartments on the eastern side. Oh, I lost my thing again. Towards Anderson Road. A bump in the road occurred at this point because the neighbors along Anderson appealed the GDP. So as a result of that appeal, settlement discussions were held and a settlement agreement was reached with the neighboring property owners. The settlement required us to remove the GDP from lots 5, 6, 19, and 20, basically these properties. So this leads us to Exhibit A3-4. which is an amended GDP that was approved by the zoning board in 2020. So a year later, under 2020-09 resolution. And as you can tell, these are lots on the right they're back in the woods, or lots 5, 6, 19, and 20. So those lots were removed from the general development plan. And the residential units that were approved, that were proposed in the back, were moved over here. So this GDP, although on a lesser, the tract remained 286 acres, but the GDP included the 500 residential units on lot 1, as well as the same commercial pads along Monmouth Road. It was at this point in time that the ordinance was modified. Recall that this was the highway commercial zone, this whole property, and a new overlay zone was developed, which is the zone that we're guided by today for this application, which is the highway commercial mixed-use zone. That ordinance was ordinance number 244-57.2. Was adopted by the Township Committee on February 11th, 2020. The overlay zone includes those areas generally located on the south side of Route 537 between 195 and Six Flags. And again, that's the ordinance we're got. We'll get back to that when we get down to the site planning for phase 3 and 4. At that point in time, lots 5, 6, 19, and 20 were not in the GDP, but remained in the contract. So they remained part of the tract. So the question was what to do with those properties. So please, Anthony, go to A3-5. So a site plan was prepared. The highway commercial mixed-use zone introduced a number of uses that were not permitted in the highway commercial zone, but are permitted in the highway commercial mixed use, such as residential, but it also included warehouses. So the warehouse use was proposed on lots 5, 6, 19, and 20. Because those uses were permitted by the highway commercial mixed use zone, that application was submitted to the plan, and it was disconnected from the GDP because of the resident settlement demands. So that application proceeded in front of the planning board. And there were 2 warehouse buildings. Again, the warehouse use was permitted. There was no variances requested. And that project was approved and has subsequently been constructed. We next, to implement the GDP, we next did some revisions to phase 1. If you can go to A3-6, please, Anthony. So now we build, right? So phase two is an approved site plan. And now we have phase 1. As you can see, phase 1 expanded from the lot 2 to include these 2 lots, 3 and 4, and it included the pads. Now we've converted the GDP to a site plan, which is the intended procedure. You start with the GDP master planning type document, you proceed to a site plan, you go to construction. So we have the air dome still here, the ball fields, and we did the hotel. We have 2 hotels and the convenience and fast food on the road. So that project was approved in 2019 and 21 under Resolution 2019-16 and 2021-12 and 19. We had a couple of different applications to move things around and adjust different uses. I could spend all night going through the small details of those things. In my opinion, it's not necessary. One of the things that was introduced at this period of time was a parking garage structure, and that is notable because it was the parking garage structure that required a D1 variance. It is the only D1 variance that exists on the entire property, and it's simply because a parking garage, parking is included in the ordinance, but a parking structure is not specifically noted, so it was the determination of the zoning board that a D1 variance was required, so that was obtained. Phase 1 also included the medical research campus, which is very near and dear to Mr. Cardinale's heart, as well as a medical school. Again, the hotels and the fast foods. Important also to understand the public benefits that this project has provided, because when we started, one of the main constraining factors of this site that go all the way back to when I started working with the Vinciguerras, and the Vinciguerras spoke to the Scots trying to buy that property, But one of the main constraints was, if you could zoom in, please, Anthony, right here. Right along Monmouth Road, you have Pine Drive, which is in Millstone Township. Of course, Monmouth Road is the boundary of Ocean County. I should have said that. But you had this black line here was the old jug handle. That was a left-turn jug handle for Pine Drive. Monmouth Road is a bifurcated road. It has a center dividing island for the last 20 years or so. And that was a constraining factor on how to get access to this property when you have this jug handle right in the middle of the frontage. So after a lot of work and a lot of meetings and a lot of money spent, honestly, a new jug handle was developed with the main road system, the main access extension of Pine Drive, a new signal constructed in Monmouth Road, and this jug handle was actually owned by DOT, believe it or not, even though it's on a county road. So it took actually going to the State House Commission in Trenton to get that right-of-way vacated to allow the new jug handle to be built. So that is the type of forward thinking that created this project and the combination of properties. But that was all done. And all of that highway work has been constructed. What you see in black and white here, you'll see on an aerial shortly, has all been completed. Then we move to, now we get into the end of the project where we're going to be asking for site plan approval, and that's Exhibit A3-7. Anthony, please. So phase one at that point in time and to this date, or up till today, is relatively established. And then we turned our attention to phase 3 and 4, which is the Lot 1, the Vince Guerra property. So phase 3 was, and there were significant challenges of planning, especially planning in a marketable way for this part of the project, because I probably should have colored it, but there's significant freshwater. The reason this is all white here and no buildings is that's all wetlands. And there's also wetlands in the back here. So there's actually, and there's a stream corridor that bifurcates the site in the northeast, southwest direction here. So what we call phase 3, which is what's on the exhibit now, and phase 4, which we'll see in a second. As you can see, phase 4 is landlocked from the highway, right? You can't even see it. So how do you develop commercial uses or any type of use that's marketable back here? That has been a challenge that is driven. Not to mention the fact that the athletic fields, they're so far removed from the highway. How do you do that? So here we have what we tried to do that. And phase 3 was approved in Exhibit A37 was approved in 2021 under Resolution 2021-18 for commercial and residential uses, all as permitted. All of the uses that I'm describing in phase 3 and 4 and in phase 1 that I described in the 2021 amended approval, all the uses, with the exception of the parking garage, were permitted under the 8 CMU zone. This was for a combination. This was for mixed use with apartment buildings, with commercial on the first floor. This was approved for 481 residential apartments, including 433 market apartments and 48 affordable special needs affordable units, along with 70,000 square feet of commercial building area in the first floor of the mixed-use buildings closer to Monmouth Road. And that was approved. Next, we turned our attention to phase 4, this very most difficult part of the property, again, being landlocked. And Anthony, that would be Exhibit A3-8. And you can see the development here that we subsequently received approval. Major site plan approval was granted by the zoning board in 2022, 2022-24 resolution. And phase 4 was strictly commercial uses. What was approved and proposed there is our third hotel, an indoor water park, and a surf wave pool. It was during the hearing for phase 4, and again, all the uses in phase 4 were permitted. But it was at that point during those hearings that the zoning board asserted jurisdiction over the remaining parts of the project, regardless of whether the uses are permitted or any variances are requested. So again, that is important to say out loud because that is why we're here for phase 3 and 4 that we're going to again talk about in a minute. So that's where we have come with the approvals. Phase 3 and 4 have never been constructed. Site work has started. The approvals were granted, site work has started. Let's turn to the next exhibit. Anthony, please, A4. And now here we are with the current day aerial. This aerial, I can't see the date with my eyes, but I believe it's January of this year. So this is a site as it currently exists. And here's phase 1. You see the air dome. There are fast food pads and stores in the front. You have the Taco Bell, Popeye's Chicken, the 7-Eleven convenience store. The building, a multi-tenant building which has Starbucks and Panda Express and well as others. We have the athletic fields in the back, and we have the warehouses in phase 2 all completed. And you could see in phase 3 and 4 the site work that has occurred. You see the disturbance, and obviously we don't see is quite a bit of, or some of the infrastructure has been built, some of the drainage systems, some of the stormwater basins. The water and sewer infrastructure has been completed in phase 1 and 2. The pump station for the entire project is located in phase 4, where my marker is now, basically in the center. You'll see me repeat back to this when we get into the site planning, but the circulation of the entire property is, again, we developed the main access with the signal to Monmouth Road, but then we have this loop road, which we call Linda's Drive. Anybody who knows Vito knows that's very important. There was a signal at this, what we call the reversing jug handle, and we have the signal at Pine Drive. So Linda's Drive connects this jug handle. This jug handle was built by Monmouth County when they bifurcated and improved Monmouth Road nearly more than 20 years ago. And they left a stub here intended for this to be a service road to connect basically the 2 traffic lanes. So phase 3 and 4 site plans that you'll see in a moment completes that access drive known as Linda's Drive to meet that master plan circulation improvement required by Ocean County. Not relevant to a land use board, but I think it's important to say out loud that the marketing of these commercial uses that were approved in 3 and 4 proved to be very challenging. I normally do not get involved with that with my clients. In this case, I was involved in many cases because, for example, we had different wave pool manufacturers, wave pool investors that were trying to do it. I personally met with 3 different ones. I'm talking world-class surfers around the world. I could give you a name, Sean Thompson, everybody knows that name. But none of them could come bring the project to fruition. Frankly, the common tale was that there's not enough rooftops, not enough houses, not enough dwelling units to drive the commercial success of the project. So that brings us to today, which is we have made the application.
Excuse me, Mr. Gordon, through the chair, please?
Yes.
Just before you get to today, how many apartments have been approved up through the application? You said?
502.
How many units? I mean,
502 were approved in the GDP.
502, and that includes how many apartments and regular townhouses, apartments, what?
Well, that was 50, there's a 10% affordable requirement, so it'll be 50 affordables and 450 market.
Okay. And usual and customary, this town has always had 20% for affordable housing. I would hope that you would think that through as we go along, and
I answer that now. The reason it's 10% is the affordable units here are special needs. And special needs offer a 2-to-1 credit under the affordable housing.
So
If you know Mr. Cardinale, special needs are very important.
that I
We
know,
developed
but-
a site
okay.
in Manalapan that has special needs housing that is occupied and functioning very well.
Okay, as
So
long as-
that,
as
that,
long as they
that's,
count
it's,
for
nobody's
that.
cutting corners. It's special needs housing, which is the most underserved part of the affordable housing market.
Mr. Ward, isn't generally a set-aside based on the number of units, not the type of the units?
Normally it is. But in this case, it was set aside by the type of unit. The ordinance, particularly the HCMU zone, requires us to do special needs affordable housing. Doesn't allow us to, it requires us
A
to.
minimum of 10%.
Minimum of 10%, that's correct.
Okay, now, the apartments or units that are approved, are any of those townhouses? Are they regular apartments? Are they for sale apartments? Are they rentals?
Are we talking about the previous
The
approvals?
previous approvals.
Previous approvals were apartments.
So all of them are apartments, and obviously they're all rentals, not for sale?
Yes, they were designed as rental apartments.
Okay, and how many bedrooms do they average?
I don't recall what the approval was for the bedroom mix. I have that in my files, I don't recall.
Okay, when you get to the answer, I would appreciate it. Okay, thank you.
So now we move to the actual project that we're in front of the town for. So again, this aerial, we are going to be speaking, Phase 3 and 4 is this area to the western portion of the project. Phase 1 is the amended site plan that we're going to discuss in March. But if you can go to the next exhibit, please, Anthony. So here we have the site plan. This is Exhibit A5, which is the Phase 3 and 4 site plan as submitted to the board. And what we have here is we are proposing to do townhouse units, residential townhouse units. Just as a matter of fact, and this is really relevant more to March 5 hearing, but just again, since we're talking about the project in totem, the commercial uses in Phase 1, which was about 70,000 square feet, and the hotel that was approved in Phase 4 have been removed from Phase 3 and 4, but they have been moved to Phase 1 that you will hear in March 5.
Forgive me, repeat that for me?
So the 70,000 square feet plus or minus of commercial, it was first floor commercial with mixed-use residential above in Phase 3. That was approved, as I noted before. And then you had what we call the third hotel in Phase 4. Those have been eliminated in the site plan that we're discussing tonight. But what I'm saying is that those uses have been moved to Phase 1. We have the amended site plan application for Phase 1 puts them back in. We just moved them from Phase 3 and 4 to Phase 1.
Thank you.
I think that's part of the misinformation that people say we wiped out the commercial by doing this. We didn't wipe it out. We're just moving it to Phase 1.
And Mr. Borden, on that note, if you don't mind, so I don't want to get you ahead, but you're right, there has been some, so if you're willing to discuss with the Phase 1, if those things are being moved over to Phase 1, what is being removed from the currently approved Phase 1?
What is being removed from Phase 1 is the most central, dearest part of the project, not being removed entirely, but moved, is the medical school and the medical campus. I mean, the medical research and the medical campus.
And that's being moved?
That is being moved. This has not been publicly discussed, but I think that is being moved to another site. If you could go back to the aerial, please, Anthony. That is being moved off of the Adventure Crossing property. Again, people talk without knowledge, and it's nice to have knowledge. Unfortunately, it's not in the aerial. When we come back for Phase 1, I'll make sure we show it. But Mr. Cardinale purchased the property on the other side of Six Flags. It's right next to the access drive. It's actually right in front of the public parking for Six Flags. He purchased the property, and my office is currently developing site plans for the medical research and medical school on that property.
Is that in Jackson or the Jackson
That's in
side?
Jackson.
Thank you.
So again,
So it's really
I wish people would call rather than talk, because they could get some information if they chose.
What fun is that?
What fun is that? It's
Could I ask for clarification? You stated that all of the commercial uses from Phase 3 and 4 that are being removed are being added in, or only?
no, I didn't say all the use. I said all the commercial in
All the
Phase 3.
commercial uses.
All the commercial in Phase 3, which is a first floor of a commercial mixed use, is moving to Phase 1 as a first floor of a mixed use. So apples to apples.
That's the only thing that's being removed
No.
when it's being transplanted, the only
Not-
commercial use.
Nope. And the
Okay.
third hotel.
And
the third
hotel.
hotel.
And that's also being moved, or
Yes.
no?
The only thing being removed from Phase 4 that no longer exists in the project, and really this applies to everything, this is the only uses being removed from the project as part of these two amended approvals we're seeking, is the wave pool and the indoor water park. That's why I emphasize the marketing. The indoor water park takes up a lot of land. It's very expensive. There's groundwater issues. You have to make a surf pool has to be very deep water. We have high groundwater here. It makes it expensive to build. Just does not work. Don't tell Doug Cleve, the planning board engineer. So what we are proposing, if you go back now to the next one, please, Anthony. 5, 8. There we go. Thank you. So now we're talking Phase 3 and 4. I think I misspoke, Dr. Hofstein. I'm looking at my notes. I have in my notes here that the GDP was approved for 560 residential units.
That was the original number, 560?
Correct. The site plan for Phase 3 was 505. I'm sorry, oof, too many numbers. What we are proposing for Phase 3 and 4 is 505 residential units. 459 residential townhouse units and 46 special needs housing units in a single 3-story building. And I'll talk through that in a minute. I'll show them on the map. But I think, not that it's right, and we require no variances for this. I'll get into the planning in a moment. But the amount of commercial in Phase 3 and 4 is less than the amount of residential in Phase 3 and 4 is less than the residential that was approved in the GDP, and slightly increased over what was approved in Phase 3. So I'm going to talk about the zoning first, and then we'll get into into some site plan details. It's important when I mentioned earlier on when I started talking about the HCMU zone. The HCMU zone was developed purposely to only apply to an assemblage of properties. As I noted, the description in the ordinance limits it to the south side of Monmouth Road between 195 and Six Flags. But the zone was purposely written so that any one of those, going back to that original aerial I showed with the different properties, the lots 1, 2, 3, 4, 5, 6, 19, 20, it was purposely written so that no one of those properties could individually qualify for the HCMU. Because the whole intent of the ordinance was to create the large project envisioned by the 2009 master plan. So basically, the HCMU zone is an overlay zone. The highway commercial zone still exists. And that's going to be relevant in a minute. So let's talk about the HCMU zone. The HCMU zone has certain tract requirements for the tract to comply and to utilize those zone requirements. And the tract requirements are that the minimum tract area is 70 acres. The tract width is 2,900 feet of contiguous frontage, not broken up in different frontages. That was tract width. Well, tract width and frontage are both 2,900 feet, and the tract depth is 1,000 feet. And the total assemblage of lots 1 through 6, 19, and 20 complies with that requirement because the tract area is 286.5 acres. The tract width and frontage is 4,300 feet, so greatly exceeds the 2,900, and the tract depth is 2,950 feet. These facts and figures that I just read are found in many of these resolutions that I quoted in my description. And it is the it is the HCMU zone that permits multifamily residential units pursuant to Chapter 244-57.2E. I know we've discussed this, but let me put it on the record. The density permitted by the HCMU zone that existed at the time of the application being deemed complete on December 11th, 2014, is 4 units per gross acre. It's already been determined and agreed upon that the subsequent ordinance 3324 adopted by the council is not applicable to this project, nor is applicable to the Phase 1 being reviewed in March, but we'll discuss that. The proposed density of Phase 3 and 4 is 1.76 units per acre, much less, of course, than the 4. The ordinance further says, as we just talked about, that a minimum of 10% of the dwelling units shall be reserved for special needs affordable units. So we have provided 46 special needs units in a single 3-story building located in Phase 4. The special needs building, looking at the exhibit, is on the right side adjacent. You have Phase 1 on the right side. You have Six Flags on the left with Monmouth Road on the top. It's adjacent to Phase 1, I'm sorry.
I'm sorry, did you say 46 units? I thought you said 50 before. What did I miss?
46 units.
That's 46.
I think the 50 units was part of the GDP. That was the old approval.
Oh, okay.
Through the
Thank
chair?
Yeah.
It does say on the plan 58.
Sorry?
On this plan that you had proposed up on the wall?
Yes, that's actually
It
one of
says
the,
58 units.
that's actually one of the comments in the, that is a typographic error on the plans. The actual number is 46.
Thank you.
And how many regular units are there, townhouse units?
459.
457. 459.
The special needs affordable housing will be constructed and occupied in accordance with the applicable COA and UHAC standards. The COA standards require 10% of the COA units, in our case 5 units, to be completed upon CO of our 116th 116 townhouse, which is 25% of the total plus 1. Since this is a multifamily building with the affordables, the entire building would obviously have to get built to occupy those 5 units. The HCMU standards, the residential standards in the HCMU zone also require that the roadway and parking improvements comply with the residential site improvements, which we do. Again, we'll get into that in the site plan testimony in a moment. There are also standards for maximum building size and minimum building setbacks to other buildings and parking. The planner's review correctly determined that the plans that we originally submitted to the board contained 5 different types of variances for building setback from internal access drives and parking areas. We did submit revised site plans on January 24, eliminating those setback deficiencies, and we are requesting no variances. To wrap up the HCMU requirements, the ordinance limits building coverage to 30%. We are proposing for the total tract 20%. The impervious coverage is limited to 75%, and the entire tract proposes an impervious coverage of 46%. So that is the zoning for the multifamily residential, the fact that they are permitted in the HCMU zone, and we meet all of the zone requirements. So no variances are required for the residential units. We do have another use proposed on the property, outdoor recreation use. We have a paintball play area, which is the shaded area on the top of the plan. That is intended to be an outdoor recreation use complementary to Phase 1, where we have the outdoor play or field areas in the air dome, which has a large recreational component. It was questioned in the planner's letter if a paintball use requires a D variance. It does not, because the paintball is a permitted commercial recreation activity, which is a conditional use under Section C of the Highway Commercial Mixed Use Zone. The Highway Commercial Mixed Use Zone, in addition to the list of uses not included in the Highway Commercial Zone, also permits all uses in the Highway Commercial Zone. And commercial recreation activity is a permitted use in the Highway Commercial Zone. Recall that I had in the Phase 1, the original Phase 1 that dates back to 2017, we have the outdoor softball fields, baseball, soccer fields, those were approved under that same section of the ordinance as a permitted use. So the paintball is a permitted commercial recreation activity.
So that won't just be for residents, Mr. Board, and that'll be a commercial use that anybody could utilize?
That is correct.
Thank you.
The building and parking for the commercial recreation for the paintball will be located in the existing air dome. The existing air dome has recreational uses, has an office, has a place to obviously pay when you go play golf or do any of the other activities in the building. So this would just simply another activity in the existing air dome. So as a result, there's no site plan improvements required to accommodate the paintball. We're simply providing the play area in the undeveloped portion. The portion, the play area is a forested wetland. So we're not proposing any development. And that is another question that the planner raised is, can we do this? Can we do this play area inside the wetland? And I would state that in my opinion, we can, and I have two reasons for saying that. First, the original Lot 1 owned by Vince Segura had a paintball business in there for many years, and that paintball business occupied many of these same wetland areas. So there is a historical precedent of that use on this property. And secondly, in my opinion, the proposed activity within the wetlands is not a regulated activity pursuant to the Freshwater Wetlands Protection Act, because we are not proposing to remove it. We're not proposing to remove any vegetation or perform any development activity. The forested wetland in this area is it's a forested wetland, and it has no undergrowth. It's just trees. So I think we can all envision that that's a perfect environment for paintball, because the trees themselves form the fallen trees that naturally occur in a forest, for example, form the natural play area for the paintball activity.
Excuse me, through the chair, are there any other recreation areas for the residents of the apartments and townhouses, et cetera?
We'll get to that in the site planning.
Okay, thank you.
I just want to finish up on the commercial recreation, because it is a conditional use in the highway commercial zone. So it's important to talk through there's very few, but there's a few conditional use requirements. So to be a permitted use, of course, we have to meet all of the conditions of the conditional use. And those are listed in the ordinances 244-116. And the first is that any lot upon which commercial recreation activity is proposed has to conform to the highway commercial zone standards, which we do. Lot 1 even singularly complies with the highway commercial zone. Secondly, that no building structure, active recreation area, or parking shall be located closer than 50 feet to any residential zone. Well, we don't have a residential zone on this property. It's a mixed-use zone. But the nearest residential zone is located on Anderson Road on the eastern part of the job, which is more than 1,000 feet from this area. Third is commercial swimming pools have to comply with a separate ordinance standard. Obviously, we're not proposing a swimming pool, so that's not applicable. The fourth item is that relates to amusement machines, coin-operated machines, such as video or pinball machines. You're limited to 5 machines as an accessory use. That's not applicable. We're not proposing that here, of course. And that concludes the conditional use requirements for the commercial recreation activity. So, in my opinion, that use is a permitted use. There's no, other than the play of these forested wetlands, there's no development activity associated with just use of that forested wetland. Lastly, correctly raised by the planner, was requesting testimony about what we call the cogeneration building. Anthony, if you could expand on the right side of this, and this is not working. On the, in this area. Among the many things that Adventure Crossing is doing is they're also serving to be a good steward by proposing electric generation on the property. There's a proposed, what we call a proposed microgrid on the property, as well as service from JCP&L. It's intended to complement the service from JCP&L. The microgrid provides both electric and thermal energy throughout the entire Adventure Crossing campus. It consists of two components. One is solar systems. I'm sure the members have seen that Phase 1 has existing solar panels out there that were approved as part of the Phase 1. That is one aspect of the microgrid. The second is cogeneration. Cogeneration is a system, as described in your planner's review correctly, that produces heat and electricity simultaneous in a single plant, powered by one source to create a second source. And in our case, we have the cogeneration building, which is shown on the Phase 4 plans, was already approved as part of Phase 1 and Phase 4, and that is this building right here. It's a masonry building that contains the generators. That building, again, was approved as part of Phase 1 and Phase 4, including a variance. That building is set back 15 feet from the Phase 1 line, where a side setback of 20 feet is required for an accessory building. The C variance for that setback was already granted as part of Phase 1 and Phase 4. Particularly in the Phase 4 resolution number 2022-24. Just to wrap up, I had noted earlier the fact that the only D variance for a use that exists on the property is related to the parking garage in Phase 1, which is to the right of this exhibit. It's off the exhibit, but recall from the aerial. This proposed development of Phase 3 and 4 does not intensify nor have any effect on that parking garage. That parking garage is intended for use by the Phase 1 activities. So there is no modification to that D1 variance in Phase 1 as a result of Phase 3 and 4. Phase 3 and 4 provides adequate parking under residential site improvement standards, does not rely upon nor have any impact on the parking garage. The parking garage D variance will be a subject of the Phase 1 site plan in 30 days, in March 5, because that application will seek to move the parking garage. We're shifting the location, so that will be a necessary amendment to that D1 variance for Phase 1. But it has no effect on Phase 3 and 4. So with that conclusion to the zoning testimony, there are no variances required to develop our proposed uses of residential townhouse units or the outdoor play area.
Reading through the planning report, I think it was mentioned, and Ernie could comment on that, D variance for the height of the cogeneration plant, is there?
No, the cogeneration plant is just a single-story masonry building. It's only 20 feet tall.
Okay.
I didn't see that in the letter, but there's no height for that.
Madam Chair, I have a question.
In fact, with the HCMU zone, even the air dome that received the D variance in its first iteration in 2017 now meets now meets the height requirements. So there's no D variance for any building height currently on the property.
Yeah, Mr. Borden, on the paintball, you said the closest, you got to be how far from residential?
It's over 1,000 from the off-site residential. Obviously, it's closer to our residential.
Yeah, I
but
say, is there a difference in that? I mean,
in my opinion, yes. I think the ordinance is describing off-site residential.
you think, Mr. Peters, your opinion of that?
I don't want to take any exception currently, but a couple things. It's my understanding Mr. Borden was giving a history and a background. So if we're going to do full zoning analysis, we need revised plans. Because the plans that are on file right now need many variances. And so while Mr. Borden may have revised a sketch to get rid of them 10 days before the meeting, we didn't review them. It took me 28 pages to review the first plan. So as we get into more of the specifics and the zoning issues, I'm going to reserve my right until I have a full set of plans in front of me, so we can get back and talk about each of the things that Mr. Borden has started in terms of both background and history. If we want to go through item by item, that's okay. I would ask him to address my report in some detail, but I suspect my report's going to become moot when revised plans are submitted.
Yeah.
So I'd be happy to get out a scale and measure and try to interpret what the ordinance meant. Is it to a property line? Is it to an actual use? I get what your question is, but at this point, that's one of literally dozens of questions are going to get asked about the layout. So with all due respect, if we could just wait until we see what the final layout looks like. Yes, is there a building that's in Phase 4 that's too close to a residential building also within Phase 4? That's a fair question.
I'll wait for the answer, thank you.
Okay.
Yeah, no, I completely agree. After this hearing, we will be submitting revised plans, and that review, that particular review will follow.
Thank you.
I fully agree with what Mr. Peters said. So just then to briefly talk about the site plan design, it's important, I had previously in describing the site talked about the wetlands in Phase 3 and 4, and those are primarily shown in the white areas. You can see the wetland and buffer lines that are in the rear and the front of the property. And this goes back to the work that I did with the Vinciguerra family back in before 2017 and the involvement with Mr. Cardinale. The Lot 1 had received an LOI in 2006. They actually appealed their own LOI because they didn't like some of the items contained in the LOI. And that led to a very, in my history, my experience of working in this business, a very unusual but helpful document, which is what's called the mediation and settlement agreement with the DEP. So there's a mediation and settlement agreement that's attached to the environmental impact statement submitted to the board, which is dated 2006. And what that does is it establishes the wetland limits and the wetland buffer limits in perpetuity. Normally, an LOI expires after 5 years, and because this is a mediation and settlement agreement, it does not expire. So that LOI dated 2006 remains valid. As a result, normally wetland and wetland buffers are deed restricted after a development is approved. I'm sure this board has heard that many times and has imposed that as a condition. In this case, because of the settlement agreement, a declaration of conservation easement was filed at the same time as the LOI. So that was filed in the clerk's office at the county in January 5, 2007. And that, again, that document is also contained as an appendix in the EIS. So the wetland limit, the buffers, and the conservation restrictions on those areas is firmly established and filed in the clerk's office. So those remain in perpetuity. I had mentioned in my previous discussion about myself working with the Vinciguerras on a culvert crossing. I want to talk about that for a moment. Oh, keep picking up the wrong one. Between Phase 3 and 4, we have this Lahaway Creek, and there was an existing farm road. So I, on behalf of the former owner of Lot 1, the Vinciguerras, obtained a DEP wetland and stream encroachment permit in 2007. That permit was actually funded by Ocean County, if you can believe it, because, again, the service road that I mentioned, the whole point of this Linda's Drive is to serve as a service road to take some traffic off of Monmouth Road and to direct traffic to these two signals. But that culvert crossing, in particular, that permit was a culvert crossing that not only do we put the culvert in, but we put in that part of the access road. One of the questions in the planner's letter is the opinion that possibly a wetland permit is required because this Linda's Drive crosses the wetlands. And my testimony is that no permit is required because that culvert crossing, if you look closely at the site plan, and we'll highlight that better in the next set, is actually existing. It's even curbed. So it's not pavement, it's dirt, but the curb is there, the culvert is there. There's no disturbance required to wetland or wetland buffers to do that road crossing. So, I guess we'll dig into the site plan standards a little bit. Linda's Drive, just generally talking about how we designed the site, has, I had made the statement earlier that it's in full conformance with the RISA standards, and certainly we have, Mr. Ray, for example, will testify, and he'll confirm. But Linda Drive is proposed with a 30-foot cartway with sidewalk on one side. We propose sidewalk on both sides in Phase 3 because we have units on both sides. In Phase 4, we propose it on the south side only because the only thing on the north is wetlands. All the units are on the south side. The intent is to connect the pedestrian activity to the commercial uses in Phase 1. The planner's letter notes that there were a few pieces left out on the site plans. That's part of the work that we're going to do in the submittal that we'll make before the next hearing. We'll show that connectivity of that sidewalk. The internal drive are all 24 feet wide with sidewalks on both sides. Accessible curb ramps and crosswalks will be provided at all intersections. We did provide traffic circulation plans in the set that show that the emergency vehicles, including the aerial fire apparatus, can safely traverse all the internal roads. I would note that we did receive a Bureau of Fire Prevention approval in a letter dated December 17th of 2024. I had described previously how Monmouth County, when they dualized Monmouth Road, or when they put the concrete barrier, it's 2 lanes either way with the concrete barrier, they had developed these reversing jug handles, and they kept the stub where I'm pointing now. There is some work required just to widen that, and that work, that plan has been submitted to the board as well, and it's under review at the Monmouth County Engineer's Office. Because Monmouth Road is the border of Monmouth and Ocean County, there's an agreement between the counties that the Monmouth County Engineering Department is the authority to do the engineering reviews. Even though they have no jurisdiction over the project, they have full jurisdiction over the design of the roadway. So part of our conditions of our county, Ocean County approval is to get a sign-off from Monmouth County engineer on the particular design of the road improvements. Speaking of the roadway improvements, that leads us to the singular design waiver that we have on the property, and that is the curb and sidewalk along Monmouth Road. Again, the pedestrian connectivity is all intended through the project. We had received a waiver previously in Phase 3 for a curb and sidewalk with payment to the Pedestrian Safety Fund. The reason for that is, again, this extensive area of wetlands that leads to such challenges on the property also serves to, in my opinion, limit that, because to extend a sidewalk, extend the different distance from Phase 3 to Phase 1 along Monmouth Road would require a disturbance to freshwater wetlands that I question. It doesn't meet any general permit standards, so I doubt that it could be approved, in my opinion. So for that reason, we had requested the waiver, had been previously granted the waiver, and we, again, requested as part of this plan.
Excuse me, is Monmouth County working with you on any road issues?
Yes. Monmouth County is actually very hopeful to work with, I would say. Yes. I didn't say it out loud, but in many cases, better than Ocean. But you didn't hear me say that.
Through the chair. Once you're addressing some of the roadways, that jug handle is only going to be, you can't get out of this development into that jug handle, correct?
You don't go out to the jug handle. The jug handle is intended for cars going eastbound on Monmouth Road to do a U-turn.
Right, so getting out of this development.
You would just come out to this intersection. If you can expand right here, Anthony?
That part of it is going to be a two-way, because I know right now the jug handle is obviously
is one way, right.
So what you're saying is that part of the jug handle would be.
Right. You see here, see the striping here, the chevron striping?
Got it, yes.
That basically right now it's just one way out. Now what we're doing is we're changing the striping to make this the out and this the in. Did that make sense? I hope.
It makes sense, but it's reversed. Normally,
No, it's the same as
Going
any
out
other
would
jug
be
handle.
on-
This will be your driveway in, and this is your driveway out on the right. We're not going to England here.
yeah, but
It's all good.
aren't they pulling into the jug handle and out? Which way is the jug handle? Oh, you're saying the
The
jug
jug
handle's
handle's
going the
only
other
for
way.
people going eastbound to do a U-turn.
Got it, okay.
We don't use the jug handle. We would just go in straight to the
Got it,
intersection.
perfect, thank you.
We just have to modify the striping and slightly widen the pavement on this side to accommodate the ingress lane. The signal's all in place, none of that changes. Our improvements for this project, the improvements for Phase 1 that I described earlier were extensive. The improvements for this phase are de minimis.
Thank you.
Is that the only entrance and exit for the apartments?
Well, recall that no, because it loops through to the traffic signal at Pine Drive.
Okay, so. in
It
an
goes through
emer-
Phase 1.
So if there's an emergency, people from the apartments can
We have
get
two
out.
signals on both sides. That's why Linda's Drive, again, is the service road that goes through the entire project. What did I say? Oh, Linda's Way, I'm sorry. I'm going to hear about that later. I'm going to talk about parking and stuff, but again, as Mr. Peters had noted, what I'm describing next might not be reflected in the plans that were submitted. So this will be, what I'm testifying to will be reflected in the plans that will be provided to the board after this hearing concludes, so that you have adequate time to review for the next hearing. The parking that we propose for the project will be fully conformance with the residential site improvement standards. RISIS requires 2.4 spaces for each townhouse. Each townhouse contains a 2-car garage and a 2-car driveway. RISIS states that a 2 and 2 combination counts as 3.5 spaces, but for that combination to work, the driveways have to be wider than what we proposed. So our 4 spaces actually count as 3 because the driveways are not 20 feet wide. So for each townhouse unit, we have 3 spaces where 2.4 spaces is required, so we have more than enough parking. The 2.4 spaces includes the half a space required for guest parking. However, the RISIS requires that the guest parking be located on a street or in common parking areas. So a extra driveway space may not be counted as part of the guest parking. So we will provide there's 228, that's half of the 459, 228 guest parking spaces required either in common parking areas or on street, and our plans that we're going to provide will provide that amount of common area or on-street parking. We are proposing 46 spaces for the special needs affordable housing. This is really going to be testimony that Mr. Ray is going to give, but in our opinion, the residential site improvement standards don't apply to that building because of this, again, it's special needs. It's not just, these aren't one-bedroom apartments, these are special needs. Typically, special needs units are more of a, being our experience in developing a special needs building in Manalapan Township, I have knowledge in this and experience that I otherwise would not have, but they're measured by beds. Because you're dealing with special needs individuals, they don't live in individual units with a full kitchen and what we would call an apartment. They live in more of a campus, I don't know how to say it, a campus setting, where you have quads, where 4 beds to a quad, because they're under nursing supervision most of the time, or all the time. So for that reason, we have provided 46 spaces for the special needs housing because nearly all of the tenants do not drive. And our experience is that 1 space per unit meets the needs of the resident and staff, but Mr. Ray will provide more testimony, and I'm thinking out loud that we might bring in some documentation from our Manalapan site to assist the board in that when we come back. The affordable building will also be able to share with the common area parking. There will be common area parking in close proximity to to the affordable building. So, and again, we'll show that when we come back. There will be a shared parking between the affordable building and the common area parking for the residential. There is a requirement under the, now it's under residential site improvement standards for the EV-ready parking spaces that 15% must be EV-ready. That requires that 34 of our 228 must be, or 15% must be EV-ready. We will show that on the revised plans. 15% of the spaces in the affordable housing area will be EV as well. And in addition, for the multifamily units, each of the townhouse units will have a 240-volt, level 1 charging capable EV-ready outlet. So all of the townhouse units will be EV-ready. I'm nearing the end, so your sufferance is almost over. The planner's letter asked about signs. We did not show a sign on a plan. That's an omission on our part. We are permitted to have a sign as an accessory use under the highway commercial mixed-use standards under 57B6. The current Phase 3 approval includes a freestanding sign. It's a small sign having a height of 45 feet and a sign area of 458 square feet with 400 square feet of digital. Yes, I'm giving you some of the time I'm going to propose. I mean, I could. Yes. We're.
Testimony about things that are going to be on a plan that hasn't been.
Yes. You don't have to take it. You don't have to take any, Ernie. You're more than welcome to have my notes.
If you feel that that's going to be beneficial, Mr. Borden, certainly.
I would. Anybody is more than welcome to have my notes.
We're having the hearing transcribed, too.
But my notes are in size 14 font.
It
because
wasn't a question of your notes or
I understand.
fonts. I'm not inquiring into that. Just
I
that
understand.
perhaps his testimony would be more useful once the
I could stop if you'd like, but let me skip over the sign. Let me skip over the sign. Let's just talk about things that are on the plans, and that the project will be serviced by public water and sewer. There's an existing 16-inch water main running along the site frontage, as well as water mains extended through Phase 1. So Phase 3 and 4 will simply loop those water mains. The site is located within the normal northern water treatment sewer service area per the Ocean County Water Quality Management Plan. Gravity sewer will be extended throughout Phase 4 to that existing pump station I noted previously. Phase 3 and 4 have already been approved under the former layout by JTMUA. We are currently seeking amended approvals from that agency.
There is capacity, Mr. Borden?
Yes. Refuse and recycling collection for the individual townhouse units will be the standard system of any townhouse or single-family house in Jackson, which is RoboCans for private pickup for separately trash and recycling. The garage does contain adequate storage for those RoboCans. That will be architectural testimony to be provided. That is currently on the plans. A refuse enclosure is provided for the affordable housing that will meet the township standards for separate areas for collection of refuse and trash. The homeowners association for the townhouse area will be responsible for the operation and maintenance of all parking areas, sidewalks, landscaping, lighting, and stormwater systems. The property owner of the affordable building will be required and will be obligated to perform the operation and maintenance of the affordable housing site. I'll just conclude by a quick listing of the outside agency approvals. We had submitted to the Jackson Township Police on November 21st. No response has been provided. We will be required to obtain approval from the Jackson Township Recycling Department. As I noted previously, the Bureau of Fire Prevention approved the project in December of '24. Jackson MUA were submitted in November. They're in the process of amending their existing approvals. The Ocean County Planning Board.
Will the revision of the plans require to resubmit to any of these entities?
No. Because the revised plans don't change the buildings and the internal layouts. The revised plans,
Just wanted to be sure.
I understand. Let's be clear. When we talk about revised plans, the plan you're going to, if I put this exhibit up and the exhibit that we come back with, you're not going to be able to hardly see the difference. The difference is only going to be, there's going to be some parking.
That's 'cause I can't keep my eyes open.
Thank you.
I'm kidding.
Uh,
You're the only person who can make jokes?
And people wonder why I don't want to go to zoning boards anymore. That's why you don't see me very often. I'm trying to stay away, trust me. They keep dragging me back in. I can get this abuse at home. But all you're going to see is some common area parking areas added. The internal road system, Linda's Way, will stay the same. The building locations will stay the same. So you're not going to really see, and we'll see a sign. We'll make sure the sign is on the plan. And lastly, we have the soil conservation. We currently have certification from them. We're amending that certification. And the Board of Health has approved the project, and we have to get amended approvals from the Ocean County Utilities Authority and DEP treatment works for sewer and for water. And as I noted previously, there is no approvals required from the NJDEP for freshwater wetlands due to the existing settlement mediation agreement and the conservation easement document.
Madam Chair, I have a question.
Yes, Mr. Bessie.
Mr. Borden, on Linda's Way, you mentioned the width. On Linda's Way, what's the width of the road?
30 feet.
30 feet. Now, and my eyes aren't that good in reading this. At any point as it goes between the townhouses and out to Phase 1, does it narrow down at all? I can't tell from looking at the plan.
It does narrow down. I'll detail this, but the plans are accurate. It does narrow down to 24 feet at the existing culvert
But the
crossing.
culvert has to narrow down, right?
Yes, just at the culvert.
And there's nothing you do with that with DEP.
Correct.
Thank you.
Through the chair?
Yes, Ms.
Question
Diamond.
also. You just mentioned a couple of those letters that you've sent out to the PD and to other agencies. When I was reviewing those letters, that was actually from the first things that I was reviewing. It says 459 residential townhouse units with 46 special needs affordable housing units.
Yes.
My understanding, reading that, was that there's 459 minus 46.
No, plus 46.
Right, so I just want to know, did you get any responses from those agencies? Did they understand it the way I originally saw it? Meaning, obviously, we didn't have the plans until now, and I didn't have what to look at until I saw our planner's review, and he actually had I think it was 515 units because of the mistake on the affordable. So I just want to know if those agencies that you submitted to had my understanding originally. Obviously, it's been clarified from the plans, but did you get any responses, and do they reflect the actual amount of residential townhomes plus?
They typically don't regurgitate the number of units back when they reply. Frankly, nor is it necessarily relevant, in my opinion. For example, Bureau of Fire Prevention, not to speak for them, but having worked with them for so many years, their concern is of access, right? Are the roads wide enough? Are they safe enough? Can they fit the emergency vehicles? What type of buildings are they? Are they 2-story, 3-story? Whether there's 5, 10, or 100 of them is not really relevant in my
So you
opinion.
do have, you have
But I would-
UA, you have
But I would
Health
further,
Department.
I would further answer that on every plan, if you look down in the bottom corner, there's a parking chart, and the parking chart lists the units, and it shows the 459 plus the 46. One. Number two, particularly with the police department, because the police department is looking at traffic, so the number of units is important to them. The traffic report done by Mr. Ray is submitted to them, which includes the total number of units. So I respectfully say there's no chance for that type of a misunderstanding if somebody is reading the traffic report and the notes on the plans.
I hope they were.
No, I'm not trying to be a smart guy.
No, I'm just saying, my question was also for the MUA, right? The capacity is obviously
Well,
large.
again, when we go to the MUA, there's the engineers reports. You have to do separate engineers reports for water and sewer. And right in the front of those reports is a chart of the numbers of units with the flows, estimated flows per unit. Again, those units are added together. So we tabulate them we add those together for every single chart report.
Thank you for the clarification.
Madam
One
Chair.
more quick, okay.
Yes, Mr. Such.
Looking at this, this is going to be set up as an association, I'm assuming? Some
Yes.
sort of, I
The
don't
the
see.
townhouse units will be fee simple, and there'll be a common area.
Okay, so I don't see.
Does that sound familiar?
Is there going to be a manager's office or some sort of clubhouse or something where someone who runs this association?
We don't propose that, but the architect can testify to that when he testifies. I mean, because these aren't rental, these are for sale, so.
No, I
There's
understand.
no need for a, on-site manager. I mean,
I'm
the
just looking
homeowners
also
association is
as-
run by the homeowners themselves.
Right. I'm just taking a risk safety aspect,
I understand.
having one set up.
I understand.
You know what I mean? It's easier to find, especially coming in a community. I do know that fire, police have difficulties finding where if there's one set address that they can go to will help them get to where they need to and
Well, one of
a
the,
public safety
one
issue.
of the requirements of the Bureau of Fire Prevention, which is reflected on the plans, is clear, very well-defined addresses on each unit. I mean, they define the size of the letters, the colors of the letters. So each unit will be marked so that they can be identified by emergency services.
Thank you.
And there is no community building proposed, as I say, on this property.
Yes, Ms.
How do
Dr.
you
Hobson.
propose to handle school buses? We have a lot of kids in the community at some point. Will there be special stops? They're not going to be put out on 537 to wait for buses, I would hope.
Well, it's up to the school board, but we, as I testified, we provide RISIS-compliant roads with stop bars and crosswalks at all intersections, sidewalks throughout the whole development. Where the buses stop, I don't know, but the entire development is meant to be pedestrian-friendly, both within the community as well as connecting to Phase 1.
Any other questions, Mr. Hyman? Any other questions, Mr. Borden?
I have a question.
Sure.
So Linda's Way is the only road to connect Phase 3 and Phase 4? Because I don't see any other roads.
That's correct, yes.
So all the cars, so the jug handle, they can get into Phase 3, but to get, or they can come into Phase 3, but then they can't get out, so they have to go all the way around through Phase 4 to get out? Because there's only one road.
They can, any unit in Phase 3 can never even ever go to Phase 4. They can go in and out of that jug handle.
Right, so with school buses, if they're going, so that's the only main road is Linda's Way to?
Yes.
Okay. That's one road with a lot of apartments.
Again, that was the design, regardless of the use. The county planning board, when they designed the bifurcated Monmouth Road, when they put that concrete divider down the middle, which means no more left turns, right? Everything goes through jug handles. That's why they designed that jug handle with that stub, and that's why they did Pine Drive, because their intention was to do this service road. Right. The Vince Aguirre's, I didn't say this, but it's relevant since the question's asked. Long before the Cardinale was involved, when I was working with them in 2006, when the county was working to divide the roadway, the Vince Aguirre's actually threatened to sue the county because the Vince Aguirre's had businesses along the highway here. If you remember, they had a bar and the Chicken Holiday and a few others. And by dividing the road, they feared that nobody could turn left into their business anymore, right? You were going to put them out of business. So for that reason, to mitigate their concerns, their reasonable concerns, the county did this stub and actually designed and paid for this part of road and actually funded the culvert crossing because of that loss of access they had by the divided road.
All right. So my question is now that there's a lot of residential homes with schools and buses going, how are the buses going in and out of these developments if there's Is there going to be other roads to,
They're going to access it through either signal, either this jug handle or Pine Drive over here. Don't forget, looking at the bigger picture, Linda's Way connects all the way up to Pine Drive up here.
all right, thank you.
Yeah. I think we just go on.
That, oh, so you guys look like you're ready for your next witness. I understand.
I was gonna say, we normally take testimony until 10:30. I don't know who your next witness is.
No,
But I would like to, be fair to people, the public.
yes.
I'm not sure who's the public party.
I don't think it's necessary to call a second witness, as it's not going to we're not going to get very far. So if you wanted this time, open up to the public. If there are any questions of Mr. Borden, based upon what testimony he's given, we're happy to address that.
Mr. Pfeffer, will Mr. Borden be available at the next hearing?
As much as Mr. Borden says he doesn't want to go to zoning boards anymore, he is coming back to the zoning board. He will be here. And as Mr. Borden indicated, there will be some revisions based upon Mr. Peters' letter, so he'll have to
I
address
just wanted
those.
to make sure that
Yes.
the board, the professionals, and the public would have
He's not getting away from this.
opportunity.
Through the
Thank
chair? Mr. Borden, you mentioned many times the GDP. I haven't seen it. Could you provide it for the board that we can review it and see what it was there and what should be there, so that we could have a proper review?
You can. It's been, yes, we could do that.
And just to clarify again, so the GDP is just exactly what it sounds like. It's a general development plan. That's what Mr. Borden indicated. You then come back for your individual, as he's indicated, as they've come back on those other sites. So really, so the general development plan, we're happy for you to review. It's part of the record. But I believe as the testimony indicated, there were separate resolutions and site plans for each phase, and those are really what control. The GDP is the general development, but each one then gets drilled down. So, and I think Mr. Borden had very well laid out all the previous resolutions, and I believe they're part of the record, and we have no problem providing copies of that as well. But just so we're clear, you may find something in the GDP that is a general plan, but
I
it's
just
the site
wanted it-
plans that
I
are.
wanted it before, to get the overall plan. I was having, honestly, I had a struggle preparing for this because we didn't have these plans until today. So, giving the GDP and fully
Okay,
revised
we have no,
plans
there's no
will
objections.
definitely
I
be
just,
very
and that,
helpful and beneficial for
and that's
the
why I
board.
asked Mr. Borden to almost painstakingly go through the history of the project, because it's important to get
appreciate
the
it.
general idea as to what happened previously.
And certainly those resolutions, all the resolutions and the GDP and everything are records of the board and
Yes.
records of this matter that are
Yeah.
available and cognizable by the board, and you can ask questions based upon them.
I would also note that Mr. Peters put together a very nice summary of the approval, dating back to 2006 with these, because that culvert, I didn't mention, that culvert, not only was it approved by DEP, but it was approved by the zone, by the planning board, because it was a development for a piece of road. But anyway, he put a very nice summary together. That's listed chronologically, and I just broke it up into more of a phase approach, but it's all the same information.
So at this point, we're going to open it to the public. If anyone is wishing to come forward at this time and speak about what was testified to tonight by Mr. Borden, please do so at this time.
Or any matter.
Or any other matter. If you are not prepared to speak tonight, understand that when they come back, you will have an opportunity to speak at that time as well. But if you'd like to come forward, please do so. All right, Mr. Revere?
My name is
Mr. Revere? Hold on one second. Please remember, you have to speak very loudly. It's very hard to hear, but Ms. Cipriani will also have to swear you in.
Okay.
Would you raise your hand, which you already have, and swear that the testimony, information, and comments that you're about to present to the board represent the truth, the whole truth, and nothing but the truth.
Yes.
Please state your name and
My name
address
is
for the
Paul. I'm Riviere. I live on West Commodore Road. Okay, the first thing I want to talk is a very... I don't want to do that on the internet. I don't know. Okay? All right, so the first thing I got is that, the applicants that come in here, they're in here for their own purposes and to, for their own businesses. The people who they hire are here to help sell that. They're not going to tell you about the problems. Okay, now, the zoning board is not the applicant. You're looking out for Jackson Township, okay? You have your professionals who are giving you what they believe is the best for Jackson Township, okay? Now, I don't know how many people have read Mr. Peters' report. Maybe you haven't. I'm not going to ask you to raise your hand, but it's very important for each and every one of you to read his report. Now, I have a question for the zoning board. Do you intend to hire your own traffic engineer, or are you?
The zoning board already has a traffic engineer.
All right. Now, have you put him on this job? I mean, an independent traffic engineer.
This is a project that would require a traffic engineer. They will do their due diligence as well. But right now, the applicant was putting on his case. That is why there was no discussion of traffic. There was no discussion of traffic tonight.
I know, I understand that. So please don't start parsing. I'm talking general here. Now, so we can expect the Jackson Township to have its own traffic engineer and not rely on the applicant's traffic engineer.
Absolutely.
Okay, that's good. Now, you're going to need a whole list of experts for this massive 1,100 home plan.
We can only discuss what was put on the record this evening. So this evening, we're not discussing 1,100 units. This evening, we are discussing 505, 459 regular units, and 46, I said that correct?
Well, you can't do that to me. You can't do that to me.
Sir.
This is 1,100.
Mr. Revere, I need you to understand, we can only discuss what was testified to tonight. We have no problem hearing your concerns, hearing your issues. We can only discuss what was testified to tonight.
I do
Please
have
come
a
back.
concern about something, and it's the totality of this site plan, overall site plan. If you parse it and make it little pieces, you're not seeing the big picture, all right? Now, there's 1,100 homes. I don't know, maybe I'm wrong by one, the exact number. This site is basically isolated from Jackson. How are all these school buses going to get into Jackson? And I'm just saying, if you parse it into these little pieces, it's not a big problem. But when you look at the whole plan, which you must do, you're going to see there's huge problems here, okay? So it's to the applicant's advantage to parse it into little pieces so you don't see the big picture.
Madam Chair,
Excuse me, Mr. Peters.
if I might, I can assure you that our review reconciles that this is part of a general development plan that, as Mr. Borden indicated, started out at 285 acres. That's not lost on us nor on our review. I would caution the board, through the board attorney, the only application before us is the application tonight. So yes, there's a separate application for Phase 1, and there'll be a similar set of reports from your professionals for Phase 1 as part of a combined 280-unit project.
Okay.
So I understand, and again, whether we explain it, whether Mr. Revere accepts our explanation, the applicant's entitled to put it in phases. They can't build 280 acres all at once. Their plans, exhibit packet that Mr. Borden created based upon the review of the history that my office prepared, I think does show the entire project. And as we go through it, Mr. Ray's traffic isn't going to be for 400 units, it's going to be the existing traffic, the traffic proposed here, the traffic proposed for the rest of the project. That's how that's how traffic engineering gets done, as it relates to parking, water, sewer. It's not lost that this is part of a bigger project, but we can only ask them questions about this part and then ask them to reconcile it with the original general development plan for 285 units. So we may not take the straight line that Mr. Revere wants to, but I think we take the circuitous route. We understand that this is part of a bigger project, but the only application that's before us is for the amended site plan for phases 3 and 4.
Okay, well, thank you for that. All right, now, in terms of experts and what Mr. Peter's doing, you're going to need an expert on cogeneration to be working for you. There's a cogeneration plant here, and you need to know exactly the negative effects of that cogeneration plant, because when you do your D1, you have to take into account all the negative effects that will impact it. Now, that cogeneration is very close to your affordable housing and other units. Now, does anybody here know anything about a cogeneration electric plant? I think you need an expert on that. So that's one point. Okay, now the traffic. And I know you're going to talk about traffic, but all these school buses have no access other than 537 Anderson Road and 571. Okay, and what schools are they going to go to? Okay, now in terms of all this background, I don't buy any of it. When they make major changes to a plan, all the previous approvals are null and void. You got to start all brand new. And I think it served us to just confuse things about this and that, what used to be. You got to do a whole brand new chalkboard and only look at what is before you now. Okay? Now, I don't know how many of these approvals have expired. New Jersey DEP has hard expiration dates. So that's another thing. I'm going to be done in a second. We got to consider pedestrians, bicycles, public transportation. Jackson is fortunate and has a lot of wetlands. And that's a good thing for the residents, because you can't build on wetlands. And that helps us retain our open space. Now, this paintball thing, that's on wetland buffers. I think we need to, as Jackson citizens, make a hard line in the sand saying, we're not messing with anything. We're not going to compromise anything environmental. All right? So if they want to use wetlands buffer, just say no. You're not going to use wetlands buffer. Okay, now this bigger thing could be you need schools. There could be a school in there. There probably needs for public safety. You have to have your checklist, because I don't know if the Jackson Township Fire Department can handle 4 or 5 floors. So there needs to be a community center.
Ms.
And
Revere, I'm
there
going to
needs
ask
to be
you
healthcare.
to sort of make your final point for tonight, because we want to see if anybody else
Well, I
has
got
any
5
comments.
minutes. Am I done? Also, I want to register myself as an objector. I want to be able to cross-examine the engineers and the traffic report when that time comes up.
You will have that opportunity.
Now, how about parks? Is there any, I don't see any playgrounds. I don't see any parks. I don't see any pedestrian roads. I don't see any bike lanes. I mean, all right, just to summarize it, I have been working for the federal government for 30 years, and this is my experience with judges, okay? If you have an engineer who explains to a judge that whatever that happened is gonna hurt the government or the town, you're not gonna find a judge who's going to kick out the engineer and play engineer. All right, so I'm not really, if you do everything right, you shouldn't be worried about lawsuits. And the second thing is no checklist, no quality. I found in previous applications that the checklist wasn't followed. And you got a huge checklist here. I mean, it's huge. This is very serious. You make mistakes, it's going to be permanent. It's going to be a nightmare permanently. These people's quality of life will be zero with no parks, no open space. And that cogeneration plant, nobody here is an expert on that. You need to find, and that's it, okay? Thank you very much.
Thank you, Mr. Revere.
Is there anyone else wishing to come forward? Seeing no one else come forward, I'm going to close public session at this time.
I was turning off my microphone. I was jumping the gun.
Judge, Mr. Pfeffer, I guess we need to come up with a date that was returned.
If possible, the applicant is asking for the second meeting in April. I think, I don't want to.
Is that acceptable, Judge? My agenda's run out.
Can we ask that the plans be submitted more than 10 days before the second meeting in April?
And Mr. Gordon whispered in my ears, ask for the second meeting because I need some time to get it done, and get it heard. So that was the reason. We
So
talked
we
about
heard
the
on April 16th, no additional notice required.
Thank you so much. Aye.
See you in 2 weeks. No, 2 weeks, 2 weeks.